nominated to the Western District of Michigan. Judge Shalina Kumar, nominated to the Eastern District of Michigan. Armando Bonilla, nominated to the Court of Federal Claims. Carolyn Lerner, nominated to the Court of Federal Claims. And Jonathan Cantor, nominated to serve as Assistant Attorney General for the Justice Department's Antitrust Division. I have the privilege of introducing Mr. Bonilla and Ms. Lerner, and we're also joined by a number of our colleagues who will introduce the other 4 nominees. Before I proceed to my introductions, I would like to make a few brief comments. First, the nominees before us are every one, exceptionally well qualified. They include a sitting federal district court judge with 14 years experience on the bench, 2 state court judges with 3 decades of judicial experience between them, a former Senate-confirmed government watchdog who saved taxpayers hundreds of millions of dollars by investigating, rooting out waste, fraud, and abuse in the federal government, a nominee who has litigated more than 100 cases before the Court of Federal Claims, the court to which he's nominated, and one of the country's foremost experts on antitrust law. Second, these 5 judicial nominees will bring incredible professional and demographic diversity to justice, to the administration of justice. Judge Koh, for instance, would be the first Korean-American woman to sit on a federal appeals court. Judge Kumar, the first federal judge of South Asian descent to sit on a district court in Michigan. Mr. Bonilla, the first ever Latino judge on the Court of Federal Claims. Further, in addition to their judicial experience, the nominees before us have worked as plaintiffs' attorneys, civil litigators for the government, criminal prosecutors, and mediators. I want to commend the Biden administration and my colleagues for continuing this important effort to balance our courts with outstanding nominees who understand the role of a judge, whose credentials are second to none and are ready to hit the ground running. Now let me turn to my introductions. Armando Bonilla is currently the Vice President for Ethics and Investigations at Capital One Financial Corporation. He's worked there since 2018. Before that, Mr. Bonilla served at the Justice Department for 24 years, 1994 to 2018. From 2017 to 2018, he served as Associate General Counsel of the United States Marshal Service, giving advice on legal, ethical, contractual, legislative, and policy issues. From 2010 to 2017, he served in the Office of Deputy Attorney General. As an Associate Deputy Attorney General, he advised the office on a wide variety of issues. He also previously served as a trial attorney, both in the criminal and civil division of the Justice Department. While in the civil division, Mr. Bonilla litigated over 100 cases before the Court of Federal Claims. He handled over 50 appeals. I will also note that Mr. Bonilla has been before this committee previously. Nominated by President Obama to be a judge on the Court of Federal Claims in 2014, this committee twice advanced his nomination by voice votes. That bipartisan support for Mr. Bonilla was well-deserved, considering his multiple decades of public service. Also before the committee today is Carolyn Lerner, likewise nominated to serve on the Court of Federal Claims. She graduated from the University of Michigan, I'm sure good news to the 2 colleagues who've joined us at the table, and New York University School of Law. Ms. Lerner spent almost 2 decades in private practice representing employees in employment discrimination and civil rights cases. While in private practice, she was appointed by a D.C. District Court judge to serve as special inspector for sexual harassment and retaliation at the D.C. Department of Corrections. In 2011, President Obama nominated her to head the Office of Special Counsel, a position to which she was confirmed by voice vote here in the Senate. In this position, Ms. Lerner investigated allegations of waste, fraud, and abuse in the federal government and protected whistleblowers from reprisal. When Ms. Lerner was nominated to serve a second term as special counsel, she had the strong support of Ranking Member Grassley, who wrote that she had, quote, built trust and confidence on both sides of the aisle in her ability to objectively and diligently pursue the office's mission. Since 2017, she has served as a chief circuit mediator on the D.C. Circuit, personally mediating approximately 10 cases each year. I'm going to ask that 2 statements be placed in the record at this point. One is from Senator Warren relating to the nomination of Mr. Cantor, who will be introduced formally later. And the other is by Senator Cardin on behalf of one of his constituents, Carolyn Lerner. Without objection, they will be entered. And let me now turn to my Republican colleague, Senator Grassley.
Ready for me?
I'm ready for you.
Judge Koh is well known for her opinions in high-profile cases involving tech companies, antitrust, data privacy. She has also had major opinions bearing on religious liberty and constitutional rights. I want to discuss some of those more in depth today and also hear more about Judge Koh's judicial philosophy. Some of this administration's nominees have been a bit cagey when it comes to their views on constitutional and statutory interpretations. Given her time on the bench, I think Judge Koh will be able to speak about her judicial philosophy very fully. The Michigan nominees are both sitting judges, which is good, but their prior experience is also pretty similar. Plaintiffs' attorneys with long histories of donating to Democrats. While there's nothing wrong with plaintiffs, lawyers, or anybody that wants to donate to any political party, including the Democrats, we should make sure that these nominees are willing to be even-handed on the federal bench. As to the claims nominees, Mr. Bonilla seems experienced before this specialized court. Ms. Lerner is someone my staff has worked with well over the years from her time as special counsel in the Office of Special Counsel. Mr. Cantor and I met last week, and we had a very good discussion about my concerns about concentration and consolidation in the agricultural industry. I hope that we'll have a chance to continue that conversation today. Mr. Cantor has been a forceful critic of big tech companies. So have I. The market size and power of companies like Facebook and Google enable them to exert substantial control over how Americans get and share information. Evidence suggests that these technology companies frequently censor conservative political viewpoints or search results from their platforms. And as we heard from whistleblower testimony yesterday, in another committee, social media companies like Facebook have prioritized profit and power over even the well-being of our children. I look forward to hearing Mr. Cantor's thoughts on how he plans to use antitrust laws to protect the American people against these types of unfair practices. I welcome all of our guests.
Thanks, Senator Grassley. We have a number of colleagues joining us this morning to introduce the nominees, and I want to note that we will go a bit out of order in these introductions so we can accommodate their conflicts in scheduling. I understand Senator Padilla will start with the introduction of Judge Koh.
Thank you, Mr. Chair and Ranking Member Grassley. It's my honor to introduce to the committee Judge Lucy Koh from the great state of California as President Biden's nominee to serve on the U.S. Court of Appeals for the Ninth Circuit. Judge Koh is joined here today by her family, her husband, Tino Cuellar, daughter, Ria, and son, Mateo. I think they're proud of Mom. So proud they took red-eye flights to make sure that they were here today. She's also joined by her mother, her brother, and several other members of her extended family. And I had an opportunity to welcome each one of them and thank them for sharing Judge Koh with us in public service. In many ways, Judge Koh's story epitomizes the American dream. She is the daughter of Korean immigrants who fled communism and dictatorship in search of a better life. Judge Koh was born here in Washington, D.C., and raised in Vicksburg, Mississippi. Her experiences there in public schools challenged with poverty and discrimination, along with the experiences of working in her father's small business, surrounded by love and lessons of her immigrant family, help shape this unique and necessary perspective that she now brings to the federal bench. Judge Koh worked her way through Radcliffe College and Harvard Law School and begun her legal career right here in this committee as a Women's Law and Public Policy Fellow. Judge Koh went on to build a career as a trailblazing public servant and an outstanding legal thinker. She spent 7 years as a lawyer for the United States Department of Justice, earning numerous accolades for her work there, including an FBI award for excellence in prosecuting major fraud. Judge Koh then found her way to Silicon Valley, where she made a name for herself as an expert litigator of intellectual property cases. Her good work and reputation extended far and wide, and in 2008, Governor Arnold Schwarzenegger, a Republican, appointed her to the Superior Court in California. Just 2 years later, President Barack Obama nominated Judge Koh to the federal district court bench. She was confirmed unanimously, Mr. Chair, unanimously by 97 members of this Senate, including members who serve on this committee today. In the decades since, Judge Koh has gone on to distinguish herself as a jurist, issuing over 3,200 opinions and presiding over more than 270 trials. She's well known, not only in her district, but across the country, as talented, thoughtful, smart, fair. In 2016, this committee, including Ranking Member Grassley and Senator Graham, voted 13-7 in support of Judge Koh's nomination to the Ninth Circuit. Unfortunately, Judge Koh's nomination never received a floor vote in the Senate. So I hope that we seize this opportunity to elevate Judge Koh to the Ninth Circuit and do so once again with strong bipartisan support. If confirmed, Judge Koh will become the first Korean American to serve on a federal circuit court. The historic nature of this nomination reflects our commitment to rebuild our federal judiciary in a way that better reflects the America that it serves. And it also is a representation of Judge Koh's great talent, intellect, and skill that the president has entrusted her with this milestone. Judge Koh, look forward to hearing from you today. I want to thank you again for your willingness to continue to serve our great nation. And colleagues, I will be urging your support of her confirmation.
Thank you, Senator Padilla. Before turning to our visiting colleagues, I'll ask Senator Feinstein if she would like to make a comment.
Thanks very much, Mr. Chairman. I would like to add my words of support for Lucy Koh to serve as judge of the United States Court of Appeals. She has been a highly respected member of the federal judiciary, and she served California well throughout her career. I recommended Judge Koh when she was first nominated to the Ninth Circuit by President Obama in 2016, and I'm pleased that President Biden chose her as one of his first nominees to the appellate court. She received her undergraduate degree from Harvard in 1990, her law degree from Harvard Law in 1993, and she has served as a legal fellow of this committee's Immigration Subcommittee and then served several years at the Justice Department. In '97, she moved to California to serve as an assistant U.S. attorney in the Central District. Among her achievements while at Justice, Judge Koh received an award from the FBI for, quote, demonstrated excellence in prosecuting major fraud cases, end quote. After her time with Justice, Judge Koh spent nearly a decade in private practice in Palo Alto. She became a distinguished intellectual property lawyer working on patent, trade secrets, and commercial civil litigation. She was appointed by a Republican governor, Governor Schwarzenegger, to serve as a judge of the California Superior Court for Santa Clara County. That's quite a good achievement. In 2010, the Senate voted unanimously 90-0 to confirm Judge Koh as a federal district court judge for the Northern District of California, and she has served on that court for more than a decade. She issued more than 3,000 written opinions, and her reversal rate is very low. It's 1.3% on all those decisions, and it speaks to the care in her research, analysis, and jurisprudence. She was nominated in February for a seat on the Ninth Circuit. Following a hearing of her nomination, Judge Koh received the support of several of our Republican colleagues on this committee, but her nomination, for some reason, was not considered by the full Senate. In the intervening 5 years, Judge Koh has gained additional experience and built a significant record as a federal judge, and I hope that my colleagues on both sides of the aisle will again support her nomination to the 9th. She has excelled in every position she has had. She has an impeccable track record as a prosecutor, in private practice, and as both a state and federal judge. Judge Koh would be an excellent addition to the Ninth Circuit. So I'm pleased once again to be able to say a few words and introduce her to the committee, and I thank the chair for holding this hearing today.
Thank you, Senator Feinstein. And now we'll turn to the comments on the second panel. And first up will be the two senators from Michigan. It's my understanding that Senator Peters has a committee waiting for him. If Senator Stabenow will defer to her colleague, I'll recognize Senator Peters.
Well, thank you, Chairman Durbin, for that, and Senator Stabenow. Thank you for the deferral for the markup for the committee, which I chair. So thank you for letting me go forward. Certainly, thank you for having this hearing, and Ranking Member Grassley, thank you for bringing us all together today. And it is my pleasure to introduce two exemplary Michiganders and nominees for the federal bench: Judge Shalina Kumar for the U.S. District Court for the Eastern District of Michigan, and Judge Jane Beckering for the U.S. District Court of the Western District of Michigan. I want to take a moment to acknowledge their families and friends who are here with us today. Judge Beckering is joined by her husband, Raymond, and 3 children, Marley, Katie, and Ray, as well as her parents, John and Sheila Buchanan, and her older brother, Robert. Judge Kumar is joined also by her close friends, Jason Turkish and Eve Hill. Thanks each of them to be here with Judge Kumar. It is critical that we have qualified, fair, and impartial judges committed to upholding our laws and administering justice in Michigan and across the country. Senator Stabenow and I were proud to recommend both of these fine judges to President Biden. As a native of Southeast Michigan, I'll begin introducing Judge Kumar, our nominee for the Eastern District. Judge Kumar is highly qualified with nearly 25 years of legal experience in private practice, and since 2007 on the Oakland County Circuit Court. In 2018, she was appointed Chief Judge of the court by the Michigan Supreme Court. And by all accounts, she has shined in this role, demonstrating effective and thoughtful public service, even amidst the challenges brought on by COVID. She has presided over a robust docket of civil and criminal cases while also leading the administration of the circuit, which has 20 judges, 400+ employees, and a $72 million annual budget. She additionally serves as the presiding judge of the Adult Treatment Court, focusing on treatment for Michiganders struggling with substance abuse and mental health challenges. Known as a trailblazer in my home state, Judge Kumar's nomination helps reflect Michigan's rich diversity. If confirmed, Judge Kumar would be the first Michigander of South Asian descent to serve on the federal bench in our state. And I'm pleased and I'm proud to recognize Judge Kumar not only for her experience, but for the diverse voice and perspective that I know she will bring to the federal bench. Now moving to the western part of the state, Judge Beckering is also a well-respected and eminently qualified jurist. For the past 14 years, Judge Beckering has served on the Michigan Court of Appeals, one of the highest volume appellate courts in the nation, where she serves as chief judge. Through her service, Judge Beckering handles appeals statewide, as well as the regular and administrative motion dockets for the court, which is based in Grand Rapids and encompasses 17 counties in Michigan. With 3 generations of lawyers in her family, Judge Beckering realized as an undergraduate at the University of Michigan that she wanted to serve others and make a difference in their lives. Following a law school graduation, Judge Beckering was a trial lawyer in private practice for 17 years and helped found the law firm of Buchanan and Beckering with her father in Grand Rapids, Michigan. Judge Beckering has helped lead the Hillman Advocacy Program, a learn by doing 3-day trial skills workshop, and is vice president of the Grand Rapids Bar Association. She recently completed 10 years of service on the Michigan Supreme Court Committee on Model Civil Jury Instruction and helped craft the definitive textbook on Michigan civil procedure law. I know that Judge Beckering and Judge Kumar will serve Michigan and our country well. These two jurists are strong legal minds who represent the best of their profession and Michigan. I have every confidence that they will be confirmed by the Senate and honorably represent Michigan and our country on the federal bench.
Thank you, Senator Peters. Senator Stabenow.
Well, good morning, and thank you, Mr. Chairman, for holding this important hearing. And Senator Grassley, it's wonderful to see you here as well. And I, too, am extremely excited about the two excellent judicial nominees from the great state of Michigan, and also want to welcome their families and friends today to this very important occasion, I know, for them. These two women have a few things in common beyond being outstanding nominees. They were both originally appointed to the court by former Michigan Governor Jennifer Granholm. They have both since been elected by the people of Michigan to the positions that they hold, and they both attended the University of Michigan. And I say that as a Michigan State University grad twice, and we're in great competition, but not today, not today. Judge Shalina Kumar is nominated to be U.S. District Court Judge for the Eastern District of Michigan, and Judge Jane Beckering is nominated to be U.S. District Court Judge for the Western District of Michigan. Since 2007, Judge Kumar has served on the Oakland County Sixth Circuit Court with great distinction. She was appointed Chief Judge of the Circuit Court in January of 2018. Prior to joining the bench, Judge Kumar spent a decade in private practice and has served continually, as my colleague Senator Peters indicated, with distinction at everything that she has done. If confirmed, Judge Kumar would be the first federal judge of South Asian descent in Michigan. Judge Beckering has more than 3 decades of legal experience. Since 2007, she has served as a judge on the Michigan Court of Appeals, is the chief judge pro tempore of the court. And before that, Judge Beckering was a trial lawyer in Grand Rapids, serving with great distinction in that role as well, and has been actively involved in West Michigan legal community activities. I am very excited for these two nominees, and I am confident that they are ready and prepared to serve the people of Michigan and serve our country on the federal bench. And Mr. Chairman, I look forward to supporting them on the floor of the United States Senate so that they can begin their service. Thank you.
Thank you very much, Senator Stabenow. We certainly appreciate your presence here today and the kind words you had to say about the nominee. The last introduction will come from Senator Klobuchar relating to the second panel before we recognize Judge Koh for her consideration.
Thank you very much, Mr. Chairman. I think this introduction couldn't be more timely with the testimony over in Commerce Committee yesterday on Facebook with the work that's going on all over the country with state attorney generals, and that is that I have the honor of introducing Jonathan Cantor as President Biden's nominee to be Assistant Attorney General of the Antitrust Division of the Department of Justice. Jonathan is joined by his wife, Lisa, and his children, Abigail, good name, that's my daughter's name, and Benjamin. We are honored that you are all here with us today, and you must be very proud of your dad and your husband. Jonathan was born in New York City, but he now makes his home in Maryland. Over the last 2 decades, he has represented numerous clients across a wide range of interests and has become one of our nation's most distinguished antitrust practitioners, respected for his deep experience and expertise, as well as his strong advocacy for vigorous antitrust enforcement. We could not ask for a more qualified nominee to lead the Antitrust Division. Jonathan began his career as an attorney at the Federal Trade Commission, where he was involved in investigating and challenging anti-competitive mergers. He went on to private practice and work for a number of prominent law firms. Then last year, he took the important step of starting his own firm, the Cantor Law Group, an advocacy-focused antitrust firm where he has continued to advocate on behalf of clients in favor of vigorous enforcement of antitrust laws against dominant firms. Over the course of more than 20 years, Jonathan has represented clients large and small before the Antitrust Division, the Federal Trade Commission, and State Attorney General.
I can't hear you.
In addition to his expertise as a practicing attorney and his knowledge of the antitrust laws, he has a deep understanding of the major competition policy issues confronting enforcers in the U.S. and around the world. That is why Senator Lee and I actually together invited him to testify before the Antitrust Subcommittee at a 2018 hearing about taking on monopolies. We are at a critical moment in antitrust. There is growing bipartisan consensus that our country has a major monopoly power problem, and I really appreciate the work of our colleagues on both sides of the aisle on this issue. We need, and we agree on this, antitrust enforcers to do more to protect competition, stop the runaway consolidation of our markets, and crack down what are actually today's robber barons. That requires leadership, experienced leadership at the Antitrust Division. That it requires legal skill as well as, and I think cannot be forgotten, the courage to take on some of the most powerful companies the world has ever seen. This doesn't mean destroying these companies, eliminating these companies. It simply means allowing competition to flourish so we can rejuvenate capitalism and have the next generation of successful companies. Jonathan Cantor possesses the skills to do this. That is why 9 former assistant attorney generals, Republicans and Democrats, wrote a letter urging the Senate to act favorably and as quickly as possible on his nomination. Vigorous antitrust enforcement, as I said, is a bipartisan priority. American consumers, workers, and businesses deserve the benefits of free and fair competition. That's why we need him, Jonathan Cantor, at the Antitrust Division. I urge my Democratic and Republican colleagues to support the nomination, and I want to especially thank Senator Grassley for the work we're doing together on competition, as well as Senator Durbin for quickly calling up this nomination hearing so we can get a leader of the division in place. Thank you.
Thanks, Senator Klobuchar. I want to thank all of my colleagues for the introductions, and I'd ask the staff, I see they already prepared the table. Judge Koh, would you please approach the witness table and stand, if you would, for a moment? Please raise your right hand. Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. Let the record reflect that the witness answered in the affirmative. Judge Koh, the floor is yours.
Good morning. Thank you so much to Chairman Durbin and Ranking Member Grassley for holding this hearing and giving me the honor of being able to participate in this hearing. I would like to thank President Biden for the honor of this nomination and to thank both Senators Feinstein and Senator Padilla for their support for this nomination and also for their very generous and kind introductions. I have with me today, and I'd like to introduce, my husband is Mariano Florentino Cuellar. He is sitting behind me with our daughter Ria and our son Mateo. My mother Unsa Koh is here, as well as my brother. My father passed away, but the 2 brothers he loved so much are here, Segon and Ugon Koh. My aunt Bangshil Koh is here, my cousin Jenny is here, and my cousin-in-law Diana Sen Ortega are here. There are so many other family members, friends, courtroom deputies, law clerks, externs who wanted to be here today, but they are joining us online, and I'd like to thank them for their support. So thank you again for inviting me to participate today, and I look forward to answering your questions.
Thank you very much, Judge Koh. You are no stranger to the committee. You've been here before and have answered questions as asked. I will just remind my colleagues that with 14 years' experience on the bench, You've issued more than 3,250 written opinions and presided over 271 total trials. There will still be efforts made by the members of the committee to ask you to be specific in your beliefs, and I know that there are certain areas where you can be and others where you cannot be. But I think the fact that you have so many published opinions should give us some indication of your judicial philosophy, as I've gleaned it from my review. But I want you to speak to another topic, which I know is very important in your life and one of the major reasons for your presence here today, and that is your family and their experience in coming to the United States. We have had so many inspiring immigrant stories. Yours is one of them, and I hope you'll share it with us now. What does this moment mean to you and your family?
So I'm sad that my father is not able to be here today because he is the first one to immigrate to the United States, and he would have loved this moment. He loved this country. He studied every single president of the United States. He dragged us around every time to see every single presidential library. He stood in the rain to watch when presidents passed away, to see their funeral processions. He made us stand in the rain to do the same, and he loved the United States and was so grateful to be here. My mother is kind of one of my heroes because she grew up in North Korea, and in 1946, in the spring, she decided that she wanted to go to South Korea, where her father was working for the South Korean government. And so she and her uncles basically escaped. It was illegal to leave North Korea. The 38th parallel had been established in August the year before, but it was porous. It was not enforced. So she and her uncles, she was about 10 at the time, walked for 2 weeks to come to South Korea, to freedom in South Korea. And along the way, they had to go through all these military checkpoints. And the uncles would go through the checkpoint, but she had South Korean currency and all their papers sewn into her undergarments. So she would just drop to the floor and she would start playing jacks so that no one would suspect she was anything but a local kid. And so then once her uncles went through the checkpoint, they would all meet up again, and they walked at night. They rested during the day because they didn't want to be seen when they were going through all the mountains. And she got yellow fever during that time, but her uncle carried her on his back they shared the load because they were all getting tired at that point. And the amazing thing is my mother never told us this story until my family, when I was in college, we were at Colonial Williamsburg, and we were walking around these fields. And my mom, who had never mentioned this, all of a sudden says, "Oh, this reminds me of the time I escaped North Korea." And we were all shocked, like, what are you talking about? And later, I actually gave the commencement address at William and Mary Law School in Williamsburg. And in my address, I said, "I hope you don't take offense, but your town reminds my mom of North Korea." So I think this is a very special moment for my family, and I'm so grateful for everyone for allowing us to be here.
Can you recount your family's experience living in Mississippi?
Yes. So we moved to Mississippi in 1972, and we first lived in Lorman, which is really a very small town. It only has Alcorn State University, which is the first African-American land-grant college in the United States. And at that time, I did kindergarten in Alcorn, went to an all-African-American kindergarten, and there were no primary or secondary schools there, so we took a 45-minute bus ride up to Port Gibson, and there we went to, my brother, sister, and I went to public schools there. My first, second, third grades were all African-American, and I just remember at the time there was an immense amount of poverty. And my mom actually was a nutrition professor, and so she was actually getting federal grants to actually measure the success of the war on poverty. So she actually did a lot of studies about the poor rural population in Mississippi to see, were these nutrition programs working? Was it enhancing their nutrition status and their health status? There was just a tremendous amount of poverty. Later, I moved to Vicksburg, Mississippi in third grade, and I thought the school was integrated. It seemed integrated to me, but later in law school, when I was an intern for the NAACP Legal Defense Fund, I learned that there was actually a consent decree for my school district in Mississippi. I think the poverty that I did see growing up is something that has always stayed with me. It's like an image that I can remember sitting on the buses and seeing some pretty dilapidated homes and little toddlers in front crying, and it was, that's been a searing memory that stayed with me.
Thanks, Judge Koh. Senator Grassley.
Judge, welcome. What you said about your Korean background reminds me a lot of what my daughter-in-law of 45 years has said. And if I learned anything from Korean people, it's a hard work ethic and how you can make a lot out of nothing. So I congratulate you and your people.
Thank you.
I've asked a number of nominees about judicial philosophy. Some nominees aren't prepared to talk about their approach or won't admit that they have a judicial philosophy. You've been a federal judge since 2010, 11 long years, so I'm hoping you can have a productive conversation with me. When it comes to describing your judicial philosophy today, would you say that you are an originalist or a textualist, or how would you want to describe your judicial philosophy?
So I do look at the text first anytime I'm asked to interpret a statute or a constitutional provision. I do look to precedent from the Supreme Court as to what methods of interpretation they have used for that particular question. So in some instances, like in Heller, like in Crawford, the Supreme Court said, yes, you look at the original understanding, you look at original sources, and so I follow the Supreme Court precedent when they have analyzed something to see how did they analyze it, what is the method that they use, and then I try to use the exact same method every time.
You were a district judge handling Tandon versus Newsom. This was a case where two Californians wanted to hold Bible studies and prayer meetings in their home. The COVID rules in California prevented them from holding indoor gatherings, even though California made exceptions for other gatherings, like, just as an example, in-home filming. When you ruled against these plaintiffs, you wrote that they had, quote, little case law to support them, end of quote, in their argument that they were treated differently and unfairly. When the Supreme Court reviewed this case, the court reversed it. The court called it unsurprising, that's their word, that the plaintiffs were entitled to host Bible studies at home because California's COVID law, quote, contained myriad exceptions and accommodations for comparable activities, end of quote. The court concluded by saying that strict scrutiny, quote, is not watered down, it really means what it says, end of quote. So my question has to do with the standard of review. You applied Smith's rational basis review to the free exercise issues in this case. Now the Supreme Court has decided a lot of free exercise cases in the last 20 years. Can you name any Supreme Court case decided in the last 20 years where Smith controlled the outcome of the case?
I actually used both rational basis and strict scrutiny in Tandon, and I relied on the precedent of the Ninth Circuit and the Supreme Court that existed at the time. And at that time, the precedent concerned houses of worship and whether the capacity limits of the houses of worship were actually considered. And there wasn't any precedent at that time of having gatherings inside at the home. And at that time, I relied on the precedent, and the Sixth Circuit had a decision that had the same rationale that I adopted, that said, if there is a rule that doesn't call out religion, because all of the other cases to that point had called out houses of worship specifically, And this one was what I thought, I understand that the Supreme Court disagreed, and that is the law of the land, and I understand. I do my best, but I don't always get it right. But they had said in the Sixth Circuit, and the Supreme Court did not enjoin the Sixth Circuit's decision, that if there is a neutral and generally applicable rule that applies to all schools, it does not call out religious schools, it does not call out public schools, all schools, that is a neutral and generally applicable rule that can withstand scrutiny. And so at that time that I made my decision, that was the law, and I did my best to follow it.
Okay. I think maybe you've spoken to this a little bit, but describe the standard that the Supreme Court currently applies to free exercise cases, and explain the legal standard in some detail.
Sure, let me do that. So I'd like to start, if it's okay, with just what the holding in Tandon is from the Supreme Court, which is the law of the land, which I will follow faithfully, fully, fairly in every future case. So actually, if I may back up a minute. So my understanding of how you analyze a free exercise case is you first look at, is this a neutral and generally applicable rule? And you first look at the text. But even if the text is neutral, if the government, when implementing that rule, had some kind of religious animus, it can still be invalid. So that's the sort of first step on neutrality. And then the second step you go to is the generally applicable. So the Supreme Court has said if there are exemptions that require the government to sort of look into, what your basis is for trying to not be governed by this rule, that's not going to be generally applicable if you got exemptions. Then the second thing that we look at is whether it's under-inclusive and overbroad. So, for example, in the Lukumi case, there were laws that on their face looked neutral, right? They applied, but it turns out that they really were just applying to Santeria practices and disposal of dead animals that way, and weren't looking at fishing, weren't looking at carcasses from hunting. And so in Tandon, what I understand the Supreme Court has now clarified is the law of the land, which I will faithfully, fully, fairly implement in any future case before me, is they said basically four things. They said, first of all, it is not neutral or generally applicable if any secular activity is treated better than religious exercise. It does not matter whether there is a secular activity that's treated equally or worse than religious exercise. There cannot be any secular activity that is treated more favorably. So that was number one. Number two, they said when you're looking at comparability, so comparability comes in when you're looking at that under-inclusive, overbroad, that second prong of the generally applicable test. They said, look, you don't look at the reason why people gather, you look at what is the government's asserted interest in imposing this restriction. You look at the asserted government interest, not at the reasons why people are gathering. And then the third thing they said is for the narrow tailoring under the strict scrutiny analysis, you have to look at religious exercise with the same precautions that you would any secular activity. So they've explicitly said you cannot assume the worst of people when they go to worship and assume the best when they go to work. The last thing the Supreme Court decided was on the issue of mootness, that it doesn't matter whether the government modifies or withdraws a restriction. If there is the possibility that the government official would reimpose that heightened restriction at a later time, the case is not moot. And so those are the holdings of Tandon, I believe, and that's how I believe it further clarified the existing framework, the existing analytical framework. And again, that is what I will faithfully, fully, and fairly apply going forward.
Thank you, Senator Grassley. Senator Feinstein.
Judge Koh, You've been a judge for more than a decade now, first in the California state courts, where you were appointed by a Republican governor, and now in the Federal District Court of California, where you were nominated by a Democratic president. How do you think your experience serving as both a federal and state court judge will shape your service as a federal appellate judge if you are confirmed to the Ninth Circuit?
So in state court, I had about 500 cases every week. And so I did criminal and civil. I also did drug court, domestic violence court, and just saw a full range of subject matter, of types of cases, of types of litigants. Similarly, in the federal court, I've had an average of about 719 cases per year. In 2017, I had 941 cases. It's a very high volume. We work very hard to try to get it right, because if we don't and we get reversed, then it comes back and we have to do it all over again. And that is just a daunting situation. Similarly, in the federal system, I've done civil cases, I've done criminal cases, and I've seen the full range of subject matter. I will say, as a trial judge, what I really appreciate is clear guidance from the appellate courts. We really are just trying to apply the law to the facts before us and the case before us. So clear guidance is really helpful. And I would say that when I sat by designation on the Ninth Circuit, it gave me a new perspective on my own cases, on how to make a record, on what I should make sure to address in my own rulings. And I'm hoping, since that experience gave me new eyes, I'm hoping that my experience as a trial judge, if confirmed, would give me just a really good perspective as an appellate judge.
I noted in reviewing your background that during your time as a judge, you have issued approximately 3,250 opinions, and you were reversed in only 43 of these decisions. By calculation, that's a reversal rate of about 1.3%, which is extremely low. What factors in your approach to deciding cases do you believe have contributed to your low reversal rate?
Well, I couldn't speak for how any appellate court reviewed my work, but I can just say that when I make any ruling, I really try to consider every single argument that the parties are making and try to be as clear as possible as to why I'm making any ruling that I'm making. So I will try to state as comprehensively as possible my reasoning. And I will say that, every reversal, I try to learn from it. I try to glean, what did I view differently that I need to view differently going forward? And so with every reversal, I learn from it and I try very hard, and I do incorporate it into my work going forward.
Thank you. Thank you, Mr. Chairman.
Thanks, Senator Feinstein. Senator Lee.
Thank you, Mayor. Mr. Chairman, thank you, Judge Koh, for being here. In your decision in Tandem versus Newsom,
Yes.
you stated a couple of things that I find troubling. I want to go over a couple of them with you. First, you stated that the right to earn a living is not a fundamental liberty interest that has traditionally been protected by the substantive component of the Due Process Clause. And then you went on to conclude, therefore, that small business owners could be restricted from operating during the initial COVID-19 period of lockdown. But in this case, also at issue was the First Amendment right to the free exercise of religion. While hair salons and grocery stores and gyms and private suites at sporting events and movie theaters, just to name a few, were allowed to accommodate more than 3 households at a time, in your opinion, you denied a group of individuals the ability to gather in someone's home for the purpose of religious worship. Now, last I checked, there isn't a constitutionally protected right, neither an enumerated right nor a right that's simply implied to get a haircut or to go to the gym or to the movies or to attend a sporting event inside of a private suite or to buy groceries. Doesn't mean that those aren't great things. Doesn't mean that those aren't things that should be free and that people should be able to do at their leisure and will. But those things don't have their own separate constitutional provision protecting them. So help me understand, Judge Koh, why it was that in this case, these religious plaintiffs were not given the same level of deference as those other people involved in other commercial commercial activities, not religious activities.
So the esthetician who gave facials, and I think it was a gym owner, the plaintiffs who were bringing the right to make a living claim were not raising a free exercise claim. And at the time I issued that ruling, and I believe so even today, there is no precedent supporting their claim, so it was denied. Now, as far as the free exercise claim, I will say the restrictions at the time did allow anyone to have religious services outside their home for up to 3 households. So it did allow it outside. The real question was inside the home. And at that time, I relied on the Ninth Circuit precedent, which said, look at the factors of risk transmission, of ventilation, of the duration, of how long are people speaking, are they singing? And I looked at those factors and the precedent that existed at the time. But I understand that the Supreme Court in Tandon has clarified this, and that is what I will follow.
Right, and the Supreme Court did clarify it, and the Supreme Court did rectify the problem using established precedent. And that's what confuses me here. That's what I'm not quite grasping, is why it wasn't more clear. I don't think anything could be clearer that there are rights that someone has with respect to the free exercise of religion that are different than one's interest in attending a gym or whatever. Now, in the Supreme Court's opinion granting injunctive relief to the free exercise claims, the Supreme Court, of course, took issue with the Ninth Circuit's failure to put the burden on California to explain why it could allow one set of activities but not another. Now, you take a similar approach to what the Ninth Circuit did. And in so doing, you named 6 specific reasons why at-home religious services were, quote unquote, more risky. And I'll quote them here. Quote, people are together for a longer time. 2, singing, chanting, shouting, loud talking, and sustained conversations are more likely to occur. 3, ventilation is poorer. 4, masking and social distancing are less likely. 5, private gatherings are not required to implement safety measures mandated by health and safety codes and industry regulations. And 6, large numbers of people may be in the same place at the same time. Now, did it ever occur to you that religious people might agree to the same safety precautions as are found in other events? And perhaps more importantly, did it ever occur to you that there are a number of features in the Constitution, including not only the free exercise of religion, but also the freedom of assembly and whatever you could make of the hybrid right that exists there, to say nothing of the understanding of the Establishment Clause that's been interpreted to also preclude the prescribing by government of means by which religious observances will be held. What troubles me is that you apparently didn't see that here. I think that's fairly plain from precedent, and it shouldn't have had to go all the way to the Supreme Court of the United States to implement not only established Supreme Court precedent, but also pretty clear mandates of the Constitution. Can you help me understand? What I'm saying here is it appears that you seem almost to be suggesting that people needed permission of government and government supervision in order to carry out these activities that are protected by multiple provisions of the Constitution?
So the factual findings that I made were uncontroverted. The plaintiffs did not dispute the risk of transmission from gatherings at the home. Now, I did that multiple factor analysis because that's what the precedent was at the time. The precedent of the Ninth Circuit at the time was you tick through these 7 factors to determine whether the risk of transmission is greater. And at the time, there was no precedent that addressed private gatherings at the home. All the precedent at that point concerned houses of worship. And even, multiple decisions had said that houses of worship restrictions that just said, in New York, they said 10 to 25 people in churches that had capacities of 500, 700, 1,000 people. And the precedent said, you must consider the capacity limits. You can't just make, and found that particular restriction was severe and far greater than any other comparable government restriction. So I understand what the ruling is in tandem. That is what I will faithfully, fully, and fairly follow going forward. But at the time, I was relying on the precedent of my circuit, which I am required to do, which said you tick through these factors of ventilation, risk, all the risk of transmission. Are there people who are going to be there longer? What is the ability to enforce any masking or any social distancing inside the home versus in a commercial enterprise? And I did what the Ninth Circuit basically told me to do in its decision. But I understand. I agree with you that the right to religious liberty is one of the most fundamental, foundational rights in our country. And I will faithfully follow tandem. But I was just doing my job at the time, which was to follow the precedent that existed in my circuit. Now, I recognize that was reversed by the Supreme Court after I issued my decision. I recognize that. But at the time, that's the precedent that existed, and I felt I had to follow it as a trial judge.
Of course, that was precedent that had never been applied to this specific set of facts, but I see my time has expired. Thank you.
Thanks, Senator Lee. Senator Whitehouse.
Judge Koh, was this decision of yours that has attracted so much attention from Senator Lee appealed?
It was appealed to the Ninth Circuit.
It was appealed on the Ninth Circuit. And at the Ninth Circuit, were there circuit judges who voted to uphold the decision?
It was affirmed by Judge Milan Smith.
It was actually affirmed.
And Judge
And
Bridget
among
Baden.
the panel of judges that affirmed it, were there Republican appointees who voted to affirm?
Yes, there were.
And ultimately, it was upheld by the Ninth Circuit, as correctly decided within the rules of the Ninth Circuit, correct?
That's correct.
And then it went up to the Supreme Court, which is obviously where these things get ultimate review, and were there Supreme Court justices who upheld or voted to uphold the Ninth Circuit's decision upholding yours?
There was a dissenting opinion saying, yes, they would have affirmed the Ninth Circuit.
And was Chief Justice Roberts among the justices?
He said he would not have adjoined the Ninth Circuit ruling.
Okay. Just wanted to make sure we were all talking about the same set of facts here. Thank you. Wish you well. Can't wait to see you on the court.
Thank you.
Senator Cotton.
Well, we're going to keep talking about the same set of facts.
Okay.
I mean, Ms. Koh, you make it sound like the Supreme Court, that was clarifying unclear law. But that's not what the Supreme Court said in tandem, which again is about people worshiping in their home, having Bible studies, and Gavin Newsom prohibiting that when restaurants and casinos and bars and strip clubs and movie studios were allowed to continue functioning. You wrote that, quote, with little case law to support them, the plaintiffs last argue that their in-home gatherings are being treated more harshly than other activities, such as filming or going to laundromats or visiting hotels. The Supreme Court, as we've heard, disagreed. Not only did they disagreed, they said that far from little case law to support them, they were overturning a ruling for the 5th time that the court had rejected Ninth Circuit cases on California's pandemic restrictions. The court noted that not only did you get it wrong in your decision, but it is unsurprising. It is unsurprising that the litigants are entitled to relief. They said not only do these kinds of restrictions require strict scrutiny, which you did not apply, you applied in the alternative, but you also said that it would pass strict scrutiny. The Supreme Court also felt the need to say that their precedent, quote, really means what it says. So I know we keep coming back to this, but we keep coming back to it because I feel like your decision was plainly contrary to the law at the time, and you keep portraying it as if it was just clarifying what was a very obscure and difficult area of the law. Is it really that obscure to say that if California wants to allow casinos and bars and strip clubs and movie studios to stay open, they also have to allow Christians to have a Bible study in their home?
So the factual evidence that was before me was uncontroverted by the plaintiffs that the risk of transmission of COVID is greater when you're in a home versus in commercial entities that are actually regulated and can be subject to misdemeanor criminal prosecutions for not complying with the restrictions. That was the evidence before me. Now, having said that, I was following the precedent of the Ninth Circuit, which I'm required to do. I'm in the lowest level position in the federal system as a trial judge. And they said you look at the risk of transmission, you look at these 7 factors, and that's what I did.
And what do you do when that Ninth Circuit precedent, as is often the case, is plainly contrary to the Supreme Court, since the Ninth Circuit is the most reverse court in America?
I don't think it's my role as a district court judge to just do what I want and ignore the higher court. I think it's my obligation to follow my circuit precedent.
Okay, so let's leave Tandon v. Newsom, the religious liberty case then, since you say it's not your role to do what you want. Let's turn to a case involving the FTC and Qualcomm. FTC, at Apple's urging, sued Qualcomm because Apple didn't like that Qualcomm's pricing structure meant that royalties on Qualcomm's chips were more expensive if the phone they powered was more expensive. So the FTC was doing Apple's bidding. You ruled against Qualcomm. You didn't just rule in the case of Apple specifically. You tried to force Qualcomm to renegotiate all of its chip contracts worldwide. And then the Ninth Circuit overruled you, finding that your understanding of antitrust law was not just incorrect, but they ruled that you were trying to implement, and this is a quote, a trailblazing application of antitrust laws. And that this trailblazing was, again, this is a quote from the Ninth Circuit, an improper excursion beyond the outer limits of the Sherman Act. So if you're confirmed as a circuit court judge, how are we to be certain that you're not going to continue to go on such trailblazing, improper incursions beyond statutory text and precedent, not just in the antitrust domain on something as important as semiconductor chips, but in every other area of law?
In the FTC v. Qualcomm case, I was actually relying on 2 precedents of the Ninth Circuit. Microsoft versus Motorola. The first case was decided in 2012. The second case was decided in 2015. They held that if you are a patent owner and you go to a standard-setting body and you tell that body, if you adopt my patents into the standard that everyone worldwide will practice, I will give anyone a fair, reasonable, and non-discriminatory license. And the court held that that obligation requires you then to give that fair, reasonable, non-discriminatory license to all comers. That is what Microsoft v. Motorola says. And that was even the understanding of Qualcomm. That is what they told the IRS in a recorded conversation in 2012. When Motorola wasn't giving a license to Qualcomm, Qualcomm made the same demand to Motorola, saying, you have a FRAND obligation, a fair, reasonable, and non-discriminatory obligation to license us your standard essential patents, because that is the commitment you made. And so repeatedly throughout the documents, we had a long, lengthy trial, and all of this was based on the record. My opinion was 233 pages. I made credibility determinations. I made factual findings. And that was Qualcomm's understanding as well throughout all the documents, that they knew they had an obligation. So I understand that the decision that I entered is completely vacated and is completely legally just invalid. So I will follow the precedent of the Ninth Circuit, but I just wanted to let you know, by defending my decision, I'm in no way saying that it's still good law. It's not. But I did just want to let you know at the time what was in my mind. I really did think that I was following the law, and I really sincerely was trying to do my job.
I understand. My time's expired. I just want to say that you say that you're following Ninth Circuit precedent. It's the Ninth Circuit that reversed you and didn't say it was a close call, said it was a trailblazing application of antitrust laws and an improper excursion beyond the outer limits of those laws.
Thank you, Senator Cotton. The order of senators asking are Blumenthal, Kennedy, Hirono. Tillis. Senator Blumenthal.
Thanks, Mr. Chairman. Thank you for your service, Judge Koh, and thank you for not only your service on the bench, but your service as a practicing litigator, and for your family supporting you here today and throughout your career. I'd like to enter into the record a letter that has been sent to the committee by Father Paul Odell of the St. Denis and Our Lady of the Wayside churches.
Without objection.
I was interested in this letter because it depicts a little bit about what your family does in the community. Maybe you can describe what you and your children do at the church, and perhaps a little bit about how you've assisted Father Paul Odell.
So for both my husband and I, our faith is very important to us. We are still friends with the priest who married us. We have promised him on our 20th anniversary we're going to take him on a Hawaii trip to celebrate. He is also the one who baptized our daughter, Ria, who's here today. Unfortunately, he got reassigned to another university and was not able to baptize. A different priest baptized our son, Mateo. But our faith is very important to us, and we love our community at St. Denis. And both of my children went through their 2-year confirmation process, which, as you imagine, for a teenager is quite a ask. It's a big ask to make a teenager to do that for 2 years. But
Probably kept them off Instagram a little bit.
But both of my children completed that program. They both received the sacrament of confirmation. We have, for many years, worked at the Maple Street Homeless Shelter, which is the homeless shelter that is just about 20 minutes from our house. And the second Sunday of every month, we prepare food. And pre-COVID, we actually got to serve it. And the kids actually also ran a bingo where we gave cash prizes to the bingo winner. And we've continued to do that during COVID, although we can't serve anymore, but we also have provided breakfast in addition to dinner as well. And we really want to support our priest who, as he mentioned, had a health issue, and we've all been praying for him and trying to provide him everything he needs to be comfortable, and he's been really wonderful to our family.
Thank you, and thank you for your service to the community. I assume that you would have no trouble separating your faith from your performance in the capacity as a judge on the Ninth Circuit and implementing the law as you see it.
Absolutely not.
Thank you. Thanks, Mr. Chairman.
Senator Kennedy.
Congratulations, Judge.
Thank
I
you.
enjoyed meeting your family. As I understand the case, the religious liberty case, you ruled that government in California could prohibit a small group of people from worshiping their God at home because of the risk of COVID. Is that basically correct?
Inside the home, outside the home, 3 households could gather.
Inside the home.
Yes.
This was in, this was in California?
Yes, the restrictions were specifically that were challenged.
Yes, ma'am.
Were
I
Santa
don't
Clara
wanna-
County
I've
and
only got a limited
California.
amount of time. I'm just trying to,
Sure.
it was in California.
That's correct.
Sorry to interrupt you. Is there something about COVID in California that makes it more likely for a handful of people in their home who are worshiping Allah or the Dalai Lama to get COVID than a handful of people in a strip club?
California, and particularly my county where my courthouse is based, had the first confirmed death of COVID in February 5th of
Yeah. Was it
2020.
in a strip club?
No, you were just asking me what were the situations in.
Yeah, this is what I'm
Excuse me,
getting
go
at.
ahead, please, sir.
In this case, didn't you want to just kind of step back and say, this is craziness? You know, my government here in California is prohibiting a handful of people from worshiping their God because of the risks of COVID. But the same people, if they want to, can go to a strip club. Does that make sense to you?
The evidence that was before me.
I understand that, but it doesn't make sense to the American people. I don't want to beat this to death. Let me ask you a couple more. Did you enjoy listening in Mississippi?
I'm sorry?
Did you enjoy living in Mississippi?
Yes, I did.
Yeah, good. You talked about the poverty in Mississippi. Where do you live now?
I live in Menlo Park, California.
Okay. Is there poverty in Menlo Park?
Yes, they're parts of, yes. That's correct.
Is it deep poverty?
I couldn't give you a
That's okay.
exact
I get it.
answer to that question.
I just want to make sure California, I'm not happy about either circumstance, but you zeroed in on Mississippi, and I just wanted to make sure you weren't picking on Mississippi.
Oh, no, I was just asked about it. Chairman Durbin specifically asked me to talk about Mississippi.
Right. Oh,
That's
he
the
did?
only reason why it came up.
Okay.
Yes.
All right.
I originally didn't mention it in my family story.
I'm just curious, do you know the name of the person who cleans your office?
Yes, Steve is the one who takes out the garbage every day. He comes by at 3 o'clock, and Eva is the one who cleans in the morning about 7 a.m.
Good for you.
Yes.
Good for you. Look, I'm not real big on holding people too accountable for crazy things they said when they were young. Because I've said a few myself. I've even done a few things. But I got to read you this from an article you wrote in when you were at Harvard Law. I'm going to quote, if that's okay. I'm not going to try to paraphrase. Here's what you wrote. Minority judges still need to maintain the disguise of objectivity or face challenges to their decisions. Yes, a minority judge is going to identify with the minority party's experiences. But she can't admit this. We've got to get more clever and say, look, we're just as neutral as any 60-year-old white man. Do you still believe that?
Not at all. I agree. I disagree with that 100%. It is something I said 31 years ago, my 1L fall semester year, fall of 1990, and that is completely wrong. Our rule of law absolutely depends on impartiality, fairness, and I completely disagree with that statement.
Yeah. Could I just ask, did you make that statement based on, or why did you make that statement? What were you thinking then?
I was having a conversation with 3 1L classmates in a room, and I think that statement shows a lack of maturity, shows a lack of experience in the world, shows a lack of knowledge about the law, and I completely disagree with it.
Okay. Fair enough. Congratulations.
Thank you.
I'm done, Mr. Chairman.
Senator Hirono?
Thank you very much, Mr. Chairman. Ms. Koh, I think it's really wonderful that your entire family is here, and I'm sure your father would be very proud of you. And thank you for sharing your mother's story, because it says a lot about you, I'd say. I do start all of my questions of nominees to any of the committees on which I sit, the following two questions. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No.
Judge Koh, I want to thank you for the extensive discussion we had regarding the Tandon decision, which was a recent Supreme Court decision, wasn't it, this year?
Yes, it was this year.
Okay. So it's very clear that when you made your decision in that case, you were following precedent at that time, which is why the Ninth Circuit sustained your decision, even if one of the judges on the Ninth Circuit was a Trump nominee, a Trump judge, I'd say, and then why Chief Justice Roberts in his dissent supported the Ninth Circuit's sustainment of your decision. You've made that very clear. As far as I can tell, the Tandon decision of the Supreme Court says to me that it opens the door for the argument that anytime somebody doesn't like a governmental restriction, they can argue that it interferes with their religious free assembly. Because the standard that the court set up for overcoming that kind of argument is extremely high, and I don't even know how that is, anyone can meet that kind of burden, but I'll set that aside. In National Urban League v. Ross, you enjoined the Commerce Department and Census Bureau from implementing the 2020 Census Replan, a plan adopted on August 3rd, 2020 that shortened key census data collection and processing dates. And it makes a really big difference when the time of the taking of the census is shortened in this way. And you specifically mentioned the paucity of the administrative record and found defendants had failed to consider important aspects of the problem, consider alternatives, articulate satisfactory explanations, or consider reliance interests. Ultimately, the Supreme Court decided to stay your order granting a preliminary injunction. And the Supreme Court's decision this ruling was issued as a shadow docket ruling, so we don't know what that they may have disagreed with in your decision, and in fact, we really have no idea what their legal rationale was for granting a stay. Isn't that correct?
Well, there was only one dissenting opinion. There was no opinion granting
Yes, so
the stay.
that's what happens in a shadow docket ruling. So although the stay was granted while litigation continued, what was the effect of the ruling? So the stay allowed the government to end the census count immediately, a decision that probably could not have been undone given the tight deadlines and practical difficulties. So what was the effect of this ruling? Can you discuss that a little bit?
Well, I don't know what the effect of the ruling was, but I can tell you what happened in the case is that originally the Census Bureau took almost 10 years to come up with a plan to do data collection, data processing. They did about 8 surveys. They consulted with statisticians, demographers, economists to try to get the best plan together. They put one together, but because of COVID, they had to stop field operations. And one of the big issues was the reliance interest of all the Census Bureau partners. And they went out and they advertised at food banks, on bus station shelters. This is the deadline to get your information, your census questionnaire in. And so if you keep changing the date, it's impossible for these partners of the Census Bureau to continue to keep telling people, October 31st is the new date. No, September 30th is the due date. No, October 5th is the due date. No, October 15th is the due date. It takes a lot of time and money for the Bureau partners to get that information out. And the constant shifting of the deadline makes it just harder for people to know when the deadline is and to be counted.
And I say, therefore, it makes it much harder for us to obtain an accurate census count if people are confused and all of that. And this is only one example of the Trump administration trying to really shorten or influence the kind of people who would participate in the census, because they also tried to put in a citizenship question. Thank you, Mr. Chairman.
Thank you, Senator Hirono. We have Senator Hawley, Booker, and Tillis.
Thank you, Mr. Chairman. Ms. Koh, congratulations on your nomination. Let me just ask you a baseline question about the free exercise clause in the United States Constitution. Is it limited to houses of worship? Is it limited to the physical space of a house of worship?
No, it is not.
So I'm struggling to understand your opinion in the Tandon case. I don't understand why you would think that businesses should be able to abide or should be able to be open, and people should not be able to gather to worship in their own homes. Why would you assume that people gathering in their own homes wouldn't follow the guidelines, wouldn't obey the restrictions, and therefore couldn't be trusted? Help me understand that assumption. I don't quite get it.
On my part, it wasn't an assumption. That was the scientific evidence and the only evidence on that issue that was presented in the record.
Wait, it was scientific evidence that people of faith don't follow rules?
No, but that the risk of transmission is greater inside a private home than in a commercial entity that is regulated, that can be subject to criminal penalties. I recognize...
Wait a minute.
Yes.
I'm sorry, but your opinion says, under the state's restrictions, commercial environments require masking and social distancing, a requirement that can be enforced by commercial workers. On the other hand, at plaintiffs' gatherings, it is uncertain whether participants in these gatherings would maintain social distancing.
My order also mentioned that there are criminal penalties for not complying with the restrictions on commercial entities.
Right, so you assume that because of those, that commercial businesses will comply, but you assume religious believers would not comply. I'm just trying to understand why you disfavor religious believers in this way that seems very personal.
All I can say, Senator Hawley, is that I certainly have no animus toward any person of faith.
You think maybe you have an implicit bias? Let me ask you this.
No, but
in the 2020 Women's Collective Summit, you said last year that stereotypes are deeply embedded in many people. I'm quoting you now. And they may not even be aware that they're there. Do you think maybe that describes your view towards people of faith? I mean, has the Supreme Court's reversal of you maybe prompted you to confront some implicit biases you may have against people of faith?
I'm a person of faith, so I would have to be having a bias against my own.
So you're telling me no? The answer is no?
I do not believe that I am biased against people of faith. I'm a person of faith. My whole family is a family of faith.
Let me read you what the Supreme Court said about your reasoning. They said, you cannot assume the worst when people go to worship, but assume the best when people go to work. Why did you assume the worst when people go to worship?
I did not assume the worst.
So they're wrong about that?
No, I'm just saying that at the time, I looked at the evidence before me, and I looked at the Ninth Circuit precedent at the time, which was you're supposed to look through these 7 factors about increased risk of transmission. And that's the precedent I followed. I completely will fully, faithfully, fairly, in every case going forward, adopt all 4 of the holdings that the Supreme Court made and clarified in Tandon. And I understand you cannot assume the worst of people as they go to worship.
But you think the Supreme Court misdescribed your opinion in this regard when they said the state cannot assume the worst when people go to worship, but assume the best when people go to work? You think that's a misdescription?
I understand that's the law, and that is what I'm going to follow. I certainly had no intent to do that. At the time, I was following existing Ninth Circuit precedent and looking at risk of transmission and making findings based on the record, which is what I understand to be my job. I understand now that comparability has to be assessed in a different way. I understand that what the rule is on the narrow tailoring for strict scrutiny analysis. I understand how you look at what is neutral and generally applicable. All of that clarification, I really appreciate. I did not have it at the time when I issued that ruling, but I will fully, faithfully, and fairly follow that going forward.
Well, all I can say is that I'm concerned about the tone of your opinion. I'm concerned about the assumptions that underlie it. I think the Supreme Court's reversal of it was quite significant. And I think the assumptions that people of faith can't be trusted, but people who go to strip clubs, as Senator Kennedy said, can be, is frankly pernicious and something that's worth further examination. And for those reasons, among others, I can't support your nomination. Thank you, Mr. Chairman.
Senator Booker.
Thank you very much. I appreciate the line of questioning, but I'm concerned that in some way it casts a shadow over how precious you hold ideals of faith and the freedom of religion in our country. And especially as someone who is religious and has such strongly held religious principles, and I imagine they guide a lot of your life, I think that an implication is being made that just is not true. So I want to ask you very bluntly, I love Star Trek. I am truly a devotee of that series. If in this case, if I was having a Star Trek gathering in a house, according to the data and the science that was put before you, that would be very dangerous, yes?
Yes, and under this restriction, you wouldn't be allowed to have a Star Trek gathering in your home.
Right, and so it really, whether the gathering in the home was for a religious purpose, and some people, a great book about the religions of Star Trek, you should probably read it, at least somewhere on your reading list. Whether it was a religious purpose or a club or a grouping, the science was what was compelling in this. It was the safety and the security of individuals, whether the Supreme Court overruled you or not. That was, it seems in this case, what was driving your decision, correct?
That is, and it was uncontroverted in the record. And also, you could have a Star Trek party outside your home with 3 households.
I really appreciate that, and I'm going to think about that when I go back this weekend about the New Jersey Star Trek Association. I failed to become President of the United States, but I am the president of the Northeastern Star Trek Association. So you can refer to me as Mr. President, not Senator. Thank you very much. I want you to know that the religious organizations, you have a lot of support from organizations of faith. I mean, it's pretty extraordinary. And if I can read this, this is from St. Thomas More Society of Santa Clara, and I'll submit the letter for the record, but I just want to say the end, because these are such sacrosanct American ideals to respect the freedom of religion. And I know you believe strongly in that, and I just want to say, the last sentence, which I'll read, is, "We know Judge Koh to be a person of deep-seated faith. We believe her faith will serve her well as an impartial appellate judge. We ask God's blessings on you as you consider her nomination." And that was sent to Senator Durbin and Senator Grassley. So Senator Durbin and Grassley, you have been prayed for. They ask God's blessings on the two of you. I want to say to you one last question, if I can, and then I have an issue of personal importance to me, and I apologize for doing it in a public forum. But the last question is why is having someone, would be the first Korean woman to serve as a federal judge, why is different lived experiences important for the bench when judges are supposed to be objective on the law? Why are those two different, are those conflicting ideals, this urgency that I feel to have a federal judiciary with diversity on it, with different lived experiences, yet we all, I think both sides, want our judges to be objective interpreters of fact and abide by the law. Can you explain that to me?
I think diversity on the bench serves 2 really important functions. One is to just enhance confidence in the justice system, and the second is just to reaffirm the American dream. Anyone can become a judge. That is a very powerful message to send the world and to send our own community. So I think the role modeling function that a diverse bench serves to students, to law students, to young lawyers is really valuable.
Okay, and then forgive me the matter of personal issue that I have. Did you introduce your husband before I came late to the hearing.
I did.
What
I
is his
did.
name again?
Mariano Florentino Cuellar.
Are you aware that I know your husband?
I am aware.
Okay, so I want to submit this for the record, so generations of your family will come back and read this truth. Your husband married up. Thank you very much. Thank you, Mr. Chairman.
Thank you, Senator Booker. Senator Tillis.
I was going to say Captain Kirk, but
John-Luc Picard, the haircut, the John-Luc
Senator
Picard.
Booker, I have an affinity for Star Trek as well. Maybe we should start a Star Trek caucus.
I agree.
Judge Koh, thank you for being here. Congratulations on your nomination, and congratulations to your family. I know they're probably all proud. I just want to go back briefly. I'm not going to read the statement that Senator Kennedy read. When I asked you about this in 2016, you said you completely disagree with that. I think one of the reasons why we go back 31 years and longer is the standard keeps moving here. We've gone back to high school yearbooks for what some teenager said or wrote in their yearbook as a basis for judging someone's qualifications as judge. I tend to disagree with it, but I do want to ask you a question that really in abstract. Because when you read the statement, it does say that you need to disguise it. So when you answered me back in 2016 that you completely disagreed, can I be absolutely certain that you're still not disguising that bias? And maybe one way that you could put me at ease is maybe describe some case in abstract. I know you probably won't want to get into details where you may have had a certain sympathy, but you had to make a decision in the other direction. Have you ever had an experience like that as a judge?
When I preside over any case, my personal feelings are irrelevant. That's not my job. And I appreciate that you're taking your advice and consent role very seriously, and I understand that statement is disturbing. It's disturbing to me.
I think so.
So I think it's completely a fair question, but I completely disagree with it. And I think if you look at 3,250 written opinions and the thousands of issued rulings I made on the state court, having 500 cases a week, you can see that I have been fair and impartial. My judicial oath is so important to me, and I completely do my level best to be fair and impartial in every case and to try to get it right by limiting my decisions to the facts before me, limiting my rulings to the issues before me, and following precedent. Now, as I've said, I may not get it right all the time, but that's what I'm trying.
I want to get back to, I'm the ranking member, previously the chair of the Intellectual Property Subcommittee, so I do have to get back to Qualcomm. And as Senator Cotton said, it was characterized as a trailblazing application of antitrust laws and an improper excursion beyond the outer limits of the Sherman Act. So I think you said that you wrote a more than 200-page opinion.
I did 233 pages of factual findings and
that it was
credibility
largely, or that it was at least substantially influenced by the prior Motorola case. So
That's correct.
And that was Ninth Circuit precedent. So do you, looking back at their assessment of what is now a vacated opinion, do you agree with the Ninth Circuit's interpretation in the context of the Motorola case and in the context of your finding?
The Ninth Circuit decision is the controlling law, and that is what I'm going to apply.
But I mean, it's more a matter of, and I'm not an attorney, so
Yes.
I don't know if I get you into a position where you can't answer the question based on other cases that may come before the court. But I'm looking more at more of a, I didn't think about it that way when I was writing my opinion, because they looked at the same thing. They looked at binding precedent, and then they looked at your ruling. And so I'm just trying to get a sense, did you learn from that and say if I'd really viewed it from that perspective, I would have ruled differently?
For me, antitrust is a really complex area of the law, and I certainly can see that there are different viewpoints.
Yeah.
The Ninth Circuit did not address this standard-setting body FRAND obligation directly. They
That
just
was-
said the
that's
remedy should
actually-
be in contract.
I wanna try and
or
keep
it should
the
be in
time.
patent and shouldn't be an antitrust law. So they didn't actually address Microsoft v. Motorola head on.
All
They
right.
just said you need to go to other areas of law for
Let me
remedy.
just get back
Yes.
in my remaining time. Do you think worldwide injunctions on issues involving patents and patent license issues are appropriate?
The Supreme Court has said that injunctions at any point, preliminary or permanent, are an extraordinary remedy. But the standard is, without undue burden on the defendant, you need to provide complete relief to the parties. And in antitrust law, there are a lot of once the government shows liability on the antitrust case, all of the presumptions go in favor of the government for the remedy. And in antitrust law for injunctions, you've got to basically disgorge the profits, you've got to stop the monopoly, you've got to prevent the monopoly from going forward. There are really very high bars to antitrust injunctions.
Yeah, I'm going to submit some questions for the record in the patent space, but I think that in the Ninth Circuit ruling they said, and I think this is important for our innovation economy, there's a difference between being anti-competitive and hyper-competitive. And I want to make sure that we're very clear on that distinction, because hyper-competitive in an increasingly threatening world, particularly with respect to nations like China, is exactly what we need to do to maintain our innovation edge today. But I will submit some other questions for the record. Thank you, and congratulations again to your family.
Thank you.
I'd just like to announce, since we have a second panel, that there are 4 senators, 2 Democrats, 2 Republicans, who've said they still are going to try to make it. Some have conflicts with other committees, and I want to give them the latitude and flexibility for that purpose. And one of the 4 is here now. Senator Cruz, you're recognized.
Thank you, Mr. Chairman. Judge Koh, welcome. As I look at your record is concerning from the perspective of a judge who will faithfully apply the law. As I look at your record, I see the record of someone who's been an activist her entire adult life. When you were a law student at Harvard Law School, you participated in a 25-hour sit-in in the dean's office, pressing for racial quotas in hiring at law school. At the time, you described your views of judges, where you said the problem of the American legal system was the homogeneity of the bench, and your proposed solution was, quote, minority judges still need to maintain the disguise of objectivity or else face challenges to their decisions. You went on to say, yes, that minority judge is going to identify with their own experiences, but she can't admit this. We've got to get more clever and say, look, we're just as neutral as any 60-year-old white man. What's more pragmatic, to pretend we're objective or to deconstruct objectivity itself? Now, you've tried to back away from that statement since then, but what on earth did that mean?
Let me first say I have never advocated for quotas. Quotas are unconstitutional. As I said, I do disagree with that statement completely. That was 31 years ago. Since then, I have been a federal criminal prosecutor. I have been a judge on the state court hearing 500 cases a week. I've been a federal district judge for almost 12 years, hearing 719 cases a year, and I have 3,250
So my question was, what does that mean?
opinions.
Not how many decisions have you heard as a judge? What did that mean when you said?
No, I'm just saying that there is a record to determine.
Judge, you're familiar with asking questions and answering questions. What did you mean when you said that?
It was 31 years ago. I don't recall specifically, but I'm sure I said, what I said is what I meant at the time. I think it's completely wrong. I disagree with it. That's not how I've lived my life, how I've served
So
the
I guess the
government.
challenge is what you
Yes.
said is that that at the time when you were in law school, you weren't a child, you were a student at Harvard Law School. You said that judges need to maintain the disguise of objectivity and get more clever and pretend to be objective. And a difficulty for this committee is if you were following that instruction, you'd say the exact same thing right now, wouldn't you?
I am under oath, and I am telling you that I completely disagree with that statement. And you can look at the
All right, then
271 trials I've had.
Then let's go to your judicial record, because as I look at your judicial record, I am concerned as well. Recently, you determined that a state regulation that banned Bible study, that banned collective prayer, that banned worship in an individual's home, while at the same time allowing activities like in-home commercial filming, was neutral and generally applicable. According to you, according to the decision, apparently people who attend Bible study are a greater threat under COVID than movie stars when it comes to health and responsibility. Now, that decision, of course, went up to the U.S. Supreme Court, and 6-3, the Supreme Court said, no, you're wrong. What did you get wrong?
The Supreme Court in Tandon has held that when you're looking at comparable activity, you look at the government interest that's asserted and not the reasons why people are gathering. That clarification has been very important. That is what I will fully, faithfully, and fairly apply going forward. They also
Why
said
did you
can't
think
assume.
that movie stars somehow are held to a different standard than people coming to a Bible study?
I was following the Ninth Circuit precedent. They looked at all the restrictions on the movie industry and said that the risk transmission risk was lower because of all the restrictions. They had mandatory multiple testings per week, and they had a lot of restrictions that said that they had scientific evidence that the risk was lower.
Your opinion applied rational scrutiny to this restriction on religious freedom. The Supreme Court reversed that and applied strict scrutiny. There's a world of difference between rational basis and strict scrutiny. Again, why did you get it so wrong? And how can the American people have comfort that if you're a Court of Appeals judge, you will faithfully protect their rights to religious liberty?
I applied strict scrutiny as well, and I was following Ninth Circuit precedent at the time, which said you look at the risks of transmission and you go through 7 factors to consider it. And at the time, the Sixth Circuit decision, which was not enjoined by the Supreme Court, said if you have a neutral, generally applicable rule that applies to both religious schools and public schools and other private schools, that survives strict scrutiny. And so the precedent that existed at the time is what I followed in issuing my decision.
Did you answer my second question?
I fully understand that Tandon is the law of the land. That is absolutely what I will follow, that you cannot assume the worst when people go to worship and assume the best when they go to work, and that you have to look at the government interest at stake, and that all of the rulings and holdings in Tandon, that's the law of the land. That's what I will apply going forward in any case that raises these issues.
Thank you, Senator Cruz, Senator Ossoff, Senator Blackburn, and Senator Padilla.
Judge Koh, congratulations on your nomination. And thank you for enduring this process. Thanks to you and your family for your commitment to service. If confirmed, Judge Koh, you will become the first Korean American woman to serve as a federal appellate judge. When you became a district judge in 2010, you became the first Korean American woman in the nation to serve as a federal judge. Could you share with the committee a little bit about your family's story, the barriers you've broken, and the importance of diversity on the federal courts?
Let me start with the importance of diversity on the federal courts. I think it is so important to reaffirm the American dream that anybody can become a judge in the United States. I think also it's important to just enhance the confidence that everyone has, the community has in our justice system. I would just say that my family has lived in Mississippi, in Maryland, in Oklahoma, and California, and so many other parts of this incredible country. And we really appreciate all the opportunities that we've been given. And my father was an immigrant from South Korea. My mom had escaped North Korea as a child, and I think that they wanted to make sure that we had every opportunity as children here, and we made the most of it as much as we could. I find my mother's story of escaping North Korea and being a professor at the first African American land-grant college in the United States, which is Elkhorn, which is in Lorman, Mississippi, has been really inspiring for me, and she's, been my role model.
Thank you, Judge Koh. And you have a significant record as a jurist, spanning nearly 14 years and more than 3,000 written opinions. What are some of the lessons you've learned during your time on the bench, both state and federal, and how will those lessons inform your service on the Ninth Circuit?
So I have just had a lot of exposure to so many different areas of the law and so many different types of cases, so many types of litigants. In state court, I also did drug court and domestic violence court in addition to civil and criminal cases. I was hearing about 500 cases a week. And on the federal system, I've pretty much had everything civil and criminal as well. And it's been just eye-opening for me of how important it is to have clarity from the appellate courts, because at the trial level, we're sort of on the ground floor, and we're trying to apply precedent and apply guidance from the circuit. And it is so much of an easier task when the appellate courts are clear, and I hope, if confirmed, that I could add that perspective to the appellate bench.
Thank you, Judge Koh. Final question. Will you commit to this committee that you will uphold the rule of law, apply the law fairly regardless of your personal opinions, and ensure that the will of the federal legislature is made real across the country and in your area of responsibility?
Absolutely. Absolutely.
Thank you, Judge Koh. Thank you, Mr. Chairman. I yield back.
Thanks, Senator Ossoff. Senator Blackburn?
Thank you, Mr. Chairman, and Judge Koh, welcome. Thank you. We appreciate your being here. Do you believe it is the role of a judge to be impartial and objective?
Absolutely.
Thank you. Let me ask you about something that you wrote as you were a law student, and you wrote it for Harvard Women's Law Journal, and I'm quoting you. Minority judges still need to maintain the disguise of objectivity or else face challenges to their decisions. Yes, a minority judge is going to identify with a minority party's experiences, but she can't admit this. We've got to get more clever and say, look, we're just as neutral as any 60-year-old white man. Tactically, what's more pragmatic, to pretend we're objective or to deconstruct objectivity itself? When you sit here today and tell us that you're going to be objective and impartial, is that a disguise?
Absolutely not. And I have 14 years of a record that you can see from 3,250 plus opinions on the federal court, thousands of opinions on the state court, 271 trials. I have been fair and I have been impartial, and I have taken my judicial oath extremely seriously to impartially discharge my duties.
Do you still hold that opinion?
Absolutely not. Absolutely not.
You do not hold that opinion that you wrote in the Harvard Women's Law Review?
It was 31 years ago. I was a 1L. This was fall semester of my first year of law school. I completely disagree with that statement.
Okay.
The rule of law requires, demands, the parties are entitled to impartiality.
So you think, so your statement today would be that you do not think there is any time or occasion where a minority judge should conceal their feelings and disguise their feelings or their approaches, that they should be impartial.
Absolutely. Every judge must be impartial. I completely agree with that. And I completely agree with that.
Okay. It's of concern to us when we read statements and then someone goes to the bench and they make decisions that are counter to statements that they have made in front of us. And I'm sure you can identify with what that frustration is. So as I read those statements that you had given when you were there at Harvard Law, that was an issue of concern for me. And I'm sure you can understand why
I completely understand.
Or why it would cause question for individuals that were coming before you.
I completely understand.
Okay.
I disagree with that statement, and I think my record has shown that I disagree with that statement.
And what would you say is your judicial philosophy? Are you an originalist? How would you classify yourself?
So I look at the text first. I look for any Supreme Court precedent. I look for any Ninth Circuit precedent. And I look at those opinions to see what methods of interpretation did they use. And in cases like Heller, cases like Crawford, they use originalism. And I follow the higher courts in what either canons of construction or what methods of interpretation to use.
Okay, and do you think it is ever proper for a judge, someone in your position, to indulge their policy preferences in determining what the law means?
No.
Okay, thank you. Looks like I'm about out, Mr. Chairman. I will yield back the balance of my time, and just for the record, my clock doesn't work.
Senator, you have 19 seconds left, and we'll credit it to you on the next witness, okay?
That worked.
Thank you. Senator Padilla.
Thank you, Mr. Chair. Is that with interest accrued or no interest? Before I ask my questions, I want to take a moment to push back against some of the ridiculous claims that we've heard from the other side this morning, particularly that Judge Koh's decision in the Tandon case was either somehow hostile to people of faith or a radical departure from the law. Colleagues, I invite you to read Judge Koh's well-reasoned and detailed opinion in the Tandon case. If you read it, you'll see that Judge Koh considered and cited precedent from the Supreme Court, the Sixth Circuit, and the Ninth Circuit, consistent with a response she just made to a question from Senator Blackburn. Fact, when her decision was appealed to the Ninth Circuit, 2 judges, including a Bush appointee and a Trump appointee, agreed with her. In fact, at the Supreme Court, Chief Justice Roberts agreed that the Supreme Court did not need to displace Judge Koh and the Ninth Circuit's decisions. So this idea that Judge Koh's opinion was somehow outside of the mainstream is just plain wrong. Likewise, the idea that Judge Koh, a person of faith herself, she shared that with us today, that she's hostile to people of faith is simply ridiculous. Now, with that said, Judge Koh, is there anything else? I know there's been a lot of discussion about your decision in the Tandon case. Is there anything else that you'd like to share with the committee? Anything that you'd like to explain further about your decision here?
Well, just that at the time, I was basing my decision on the facts in the record and the precedent that existed at the time. And I was following the Ninth Circuit's analysis of looking at risk transmission evidence and looking at the Sixth Circuit decision, which was the only one that existed at the time that was not calling out houses of worship and calling out religious exercise specifically. And the Supreme Court did not enjoin that decision that said it's a neutral and generally applicable rule if it applies to public schools, private schools, religious schools. It doesn't matter because it's generally applicable and it's neutral. And that's the precedent that existed at the time. I was following Ninth Circuit precedent. I understand that subsequent to my decision, and my decision was affirmed by the Ninth Circuit, subsequent to my decision that I relied on in the Ninth Circuit, the Supreme Court ultimately reversed that decision. But at the time, I was following the law.
Okay, thank you. And as you shared, you are a person of faith yourself. So can you just clarify for the record, are you hostile to the constitutional rights of people of faith, as some of my colleagues on the other side seem to be implying?
Not at all. I understand that the right to religious liberty is one of the most important and fundamental rights. It's one of the foundations upon which this nation was built.
Thank you. And in the time remaining, I do want to sort of take a step back away from this case in particular and acknowledge what several of my colleagues have acknowledged, and that's your remarkably low reversal rate. I know several have mentioned it today over the course, just to remind us of the numbers, over the course of more than 3,200 opinions and 270 plus trials. You've had to rule on everything from mundane discovery requests to blockbuster questions regarding intellectual property. Is there a particular approach or philosophy you take to ruling on such a wide array of cases?
I try to do my best to look at the record that is before me, to decide only the limited issues that are before me, and to apply the law fairly, and to issue opinions that lay out in full comprehensive fashion what my ruling is, what my reasoning is, why I'm coming out this way, so the parties understand how I've reached that decision, so the appellate courts can see how I've come to a conclusion.
Thank you. And if I may, Mr. Chair, just in closing, question more on the personal side. By all accounts, you've already had a tremendously successful judicial career. You're one of the most respected judges in the Northern District of California and have the opportunity to preside over consequential and challenging cases in this capacity. On account of your prior confirmation to be a district court judge, you already have life tenure on the federal court. So put another way, you really don't have to be here today. So let me ask you, why are you here? Why do you choose to be here? Why did you choose to subject yourself to yet another confirmation hearing for this opportunity to serve on the Ninth Circuit?
Let me just say that the job I currently have is an amazing job, and I have nothing but the utmost respect for my colleagues. Trial court judges have, frankly, the least resources in the system and have very large volumes with tight time constraints. So this is a job that I love. But if confirmed, I would love to contribute to providing clear guidance to trial courts. I think the perspective of someone who's been sort of on the ground trying to apply it in very quick trials and very short time frame, compressed time periods is helpful. And I think that I would really love also to serve a role modeling function beyond my district, beyond my state, and to go meet law students, go meet young lawyers all over the Ninth Circuit. That is something that I really look forward to.
So, thank you very much. Thank you, Mr. Chair.
Thanks, Senator Padilla. Judge Koh, thank you very much. It would be an interesting exercise to ask all of the young people in the room that have witnessed this hearing for their impressions, but we have some other things we have to do. But there is a lesson here, something that you may write today or text today, you may have to answer for before the Senate Judiciary Committee 31 years from now. So be careful. But thank you for your patience in this hearing and for your remarkable career in the law. You've done an outstanding job. And I salute your family, including that future quarterback for the Los Angeles Chargers.
49ers, excuse me.
49ers. 49ers. Mateo, I wish you well, and Rhea, thank you so much for your patience, and to your husband as well. So thank you. If you would please give us a chance to set up now for the second panel.
Thank you
Appreciate
so
it.
much. Thank you to everyone.
Okay, if the, I want them to sit down. They sit down first. Maybe the second panel wants to sit down quick, and then we'll swear you in. I know. Okay. I was just watching Mr. Cantor do the secret handshake with his kids. Maybe when that's done, we can all learn it. I want to welcome the nominees to the second panel, which include Judge Beckering, Judge Kumar, Mr. Bania, Ms. Lerner, and Mr. Cantor. It is truly a pleasure to welcome you today. We have a long day of hearings. You're somehow sandwiched in the middle over lunch, but we're very glad for your patience, and thank you. If the witnesses now could please stand and raise your right hand. Do you swear that the testimony you will give before the subcommittee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. I'll now recognize the witnesses for 5 minutes, the nominees for 5 minutes of testimony each. We start with Judge Beckering.
Well, if the clock on the wall is accurate, I would like to say good afternoon. I would like to begin by thanking Senator Klobuchar for presiding today. I'd like to thank Senators Durbin and Ranking Member Grassley for scheduling this hearing, and I'd like to thank the other senators for participating in this advice and consent process. I'm grateful to my home state senators, Senator Stabenow and Peters, for recommending me to the President, and I'm deeply humbled by their kind words this morning. I'm also thankful to President Biden for the tremendous honor of this nomination. I have several family members here today who I would like to introduce, who are sitting behind me. First and foremost, my husband, Ray Beckering. He is an assistant United States attorney. He has been my biggest cheerleader and source of unwavering support for the past 30 years of our marriage. We have 3 adult children. Marley has come from Chicago, Illinois, Katie from Charlotte, North Carolina, and Ray from Ann Arbor, Michigan. I could not ask for 3 kinder, more considerate, or more loving children. They are my greatest accomplishment, hands down. My parents are also here, John C. and Sheila Buchanan. They are both wonderful parents and impeccable role models, and my father is the reason that I became a lawyer. And finally, my brother and best friend, Rob Buchanan, who also caught the bug and became a lawyer, is here as well, having just come off a year of service to the state of Michigan as bar president. Rob and I became lawyers because we were mentored from a very young age by 2 of the world's finest trial lawyers, my father, John C. Buchanan, and my late grandfather, William D. Buchanan. They believe that America's system of justice is the finest in the world, and that to uphold its tenets as a lawyer or a judge is among the highest of callings. They taught us that civility, integrity, and respect for others are the hallmark trademarks of our profession. I'm deeply humbled to appear before you today by honoring them for this potential opportunity to carry on my family's commitment to the stewardship of our justice system. Thank you, and I look forward to answering your questions.
Thank you so much. Next up, Judge Kumar.
Good afternoon. I'd like to thank Chairman Durbin and Ranking Member Grassley for scheduling this hearing today, and thank you, Senator Klobuchar, for agreeing to preside over this hearing. I'd like to thank President Biden for nominating me to this position. It is truly a great honor, and I am deeply humbled by the faith he has placed in me. I would like to thank Senator Stabenow and Senator Peters for recommending me to the President and for their lovely words of support today. I would like to acknowledge my mother, Margaret Kumar, who I unfortunately lost last year. She was my greatest champion, and I know today she would be very proud. I have zero doubt she is here with me today, and knowing my mother, probably orchestrating the whole thing. I'd like to thank my father, Dr. Krishna Kumar, who came to this country from India to pursue his own American dream. He always taught us to believe in ourselves and know that we could be whatever we wanted to be in life. I'd like to acknowledge my sister Kala Kumar and brother-in-law Ken Shepard and thank them for their love and support, and all my aunts, uncles, and cousins in Michigan, Maryland, Missouri, and India. I know they are all very excited about this nomination. I would also like to acknowledge my high school government teacher, Paul Dane, who was responsible for my initial interest in government and the law, and he has continued to support me in my career throughout my life. I would be remiss if I did not thank and acknowledge my staff, Amanda, Bridget, Lindsay, and James. Without their hard work, I could never do my job. I would like to thank all my friends and colleagues for their love and support throughout this process, including those here with me today, Jason Turkish and Eve Hill. I thank all the senators here today, and I'm happy to answer any questions.
Thank you. And before we go over to Mr. Pania, I will tell you that both your Michigan senators have approached me about this hearing several times. And if I mess this up, I don't know what's going to happen to me. I'm never going to be able to go in your state. So congratulations to both of you. Mr. Pania.
Thank you, Senator Klobuchar. And thank you, Chairman Durbin, for your kind introduction, and Ranking Member Grassley for your kind words earlier this morning and in 2014 when I was initially nominated. I'd like to thank the chairman and the ranking member for scheduling this hearing, and to the members of the committee for considering our nominations. I would also like to thank President Biden for the honor of renominating me to serve as a judge on the court where I learned to practice law and tried my first case 25 years ago. With me today are my wife of 17 years. We celebrated our wedding anniversary this past weekend, Dr. Jacqueline Wright Bonilla, our daughter Bryson, and our son Armando, who goes by AJ. It is with their unconditional love and support that I continue chasing this improbable professional dream. Excuse me. Seated with my family are our dearest friends and the godparents to our children, Colleen Connery and her spouse Karen Fisher, who had the honor of serving on Senator Wyden's staff, and Amy Brown Doolittle. Watching from home, after I asked and then begged them not to travel during these extraordinary times, are my mother, Aleida Bonilla, my sister, Barbara, and her partner, Bob Feldman, and my in-laws, Joy Adams, and Paul and Lenora Wright. Sadly, my father passed away 25 years ago, almost to the day, and can only be here in spirit. He was a man who quit high school to join the Marines to support his mother, and spent his life working 2 and 3 jobs to make sure that my dreams and my sister's dreams were not limited by our state and life. He and my mother worked tirelessly and raised me to truly believe that a kid who grows up cleaning law offices at night with his parents could someday be nominated by the president and considered for the federal bench. It is because of their sacrifices and their example that I am living the American dream. Finally, I would like to thank my former colleagues at the Department of Justice for their service to this nation, and my colleagues at Capital One. Throughout my career, I have been honored and privileged to be surrounded by very kind people, generous with their time and their support and their many talents. I'd like to thank the committee again for considering our nominations, and I look forward to answering your questions.
Thank you very much. Next up, Ms. Lerner.
Thank you, Senator Klobuchar.
Thank you for presiding over this hearing. I'd also like to thank Chairman Durbin, Ranking Member Grassley, the other members of this committee, and the staff for scheduling this hearing. I had the privilege of working closely with several members of this committee during my prior role as head of the U.S. Office of Special Counsel. Senator Grassley, you were one of them, and it's an honor to appear before you again today. I also want to thank President Biden for nominating me. I'm truly grateful and humbled. With me is my husband of 30 years, Dwight Bostwick, and our son, Ben. Our daughter, Anna, is a student at Stanford Law School, so unfortunately she couldn't be here, but I know she's watching by video. I am so grateful to each of them for their love and their support. Many other family members and friends are watching by video as well, and I want to thank and acknowledge them as well. I would not be here but for the two people whose influence led me to pursue a career in the law. My mother and father would have treasured this day. They were the children of immigrants who came to this country to escape anti-Semitism and oppression. My grandfather had been jailed in his country for speaking out against the government. My parents taught me to appreciate the freedoms we enjoy in the United States and to give back through public service. I began my career in Michigan, where I grew up, as a law clerk to Chief U.S. District Court Judge Julian Abel Cook, Jr. Judge Cook treated all those who appeared before him with kindness, dignity, and respect. He encouraged me to try and become a judge, and I so wish he could have lived to see this day. It will be his example that I emulate if I am fortunate enough to be confirmed to a seat on the Court of Federal Claims. Thank you, and I look forward to your questions.
Thank you very much. Mr. Cantor.
Thank you, Senator Klobuchar, for chairing today's hearing. Thank you to Chair Durbin, Ranking Member Grassley, members of the Judiciary Committee for giving me the opportunity to be here today. I'd like to thank Senator Klobuchar for that warm introduction and for her inspirational and transformative leadership promoting sound competition policy and effective antitrust enforcement.
Well, hopefully you didn't lose some votes over that. Thank you. Thank you.
So many family, friends, and colleagues, mentors have provided so much support and encouragement throughout this process and my entire career, and I'm just so grateful to all of them. I'm particularly thankful for my family here today. I love them so much. My wife, Lisa, my daughter, Abigail, my son, Benjamin, my mother and father, Leslie and Alan, Cantor, and my sister, Beth, Cantor, and all of my family who are watching at home. I'm so grateful. In 1996, following my first year of law school, I took a long drive from St. Louis, Missouri to Washington, D.C. to begin a summer internship at the Federal Trade Commission's Bureau of Competition. At the time, I could hardly imagine spending the next 25 years steeped in antitrust law, let alone sitting before you today. But I'm here precisely because others did imagine that a moment like this was possible. I think about my grandfather, Meyer Cantor. As just a baby, he came to this country with his family in 1938. They came here in pursuit of a better life and opportunity, not just for themselves, but for future generations. At first, life was hard for my grandfather. He had to drop out of school at a young age to work in support of his family. He would eventually become a plumber, where he would work long and hard hours, but with an unbounded sense of optimism and a deep love of his country. Sitting here today, I can think about it, driving with my grandfather in his powder blue Chevy. I was sitting in the back seat, and he would beam with pride as we passed by a school where he was responsible for installing the plumbing. I remember vividly my grandfather telling my sister and me about the proudest day of his life, April 26, 1938, the day he became a U.S. citizen. He not only believed in the American dream, but he lived it. He provided a whole range of opportunities that he never had to my father. My father had the opportunity to attend college, study music, eventually become an elementary school music teacher, where he married my mother, who devoted her career after similar upbringing to being an elementary school teacher. And my parents, in turn, provided me with a whole range of opportunities that they never had as I grew up in Queens, New York. I attended law school and eventually had the opportunity to build a successful career in the law. So many of us have a similar story. We've heard inspirational stories like this already today. The American dream is real, without a doubt, but we can't take it for granted. Liberty depends on opportunity, and opportunity depends on free, fair, competitive markets. And the antitrust laws play a vital role in preserving these opportunities. I have with me today my grandfather's original certificate of citizenship. It's my way of him being here with me for this important milestone in my life. If confirmed, I plan to take inspiration from my grandfather and keep this certificate at my desk at the Department of Justice as a reminder of his optimism and the importance of fighting to preserve opportunity, not just for current generations, but for future generations. I'm truly humbled to be here today. If confirmed, it would be an honor of a lifetime to work with Attorney General Garland, the leadership of the Department of Justice, and the so many talented, hardworking, exceptional people at the Antitrust Division, many of whom I've had the privilege of knowing for 2 decades. I am humbled and grateful that President Biden has nominated me to serve as Assistant Attorney General for the United States Department of Justice. I'm honored to be with you today, and I look forward to answering your questions.
Very good. I'm going to defer here to the ranking member and allow him to go first. So go ahead. Thank you.
Mr. Bonilla, your family has an impressive story. Mother, a Cuban immigrant, fled the Communist Revolution as a young woman, and like many Cubans came here to build a new, better life. Your Uncle Mario apparently disappeared trying to help others. This summer, people bravely protesting against the communist dictatorship. Tell me a little more about the oppression that your family faced in Cuba and the opportunities they were able to find with other Cuban exiles in America.
Thank you, Senator Grassley. As you pointed out, my mother, when she was 21 years old, left Havana with a suitcase and a dream. She came to a country where the land was foreign, as was the language. She and her mother and her sister moved to New York and had to leave her brother Mario behind in Cuba. Eventually, he did come to this country and settled in Miami. And every year, my family would drive our Chevy Nova down 95 with our trailer to visit them in Hialeah, and where we'd spend a week with our extended family. My Uncle Mario was a private pilot, and my grandmother saved her money and bought him a plane. And he would fly back and forth trying to rescue other Cubans out of that country who were suffering.
Can I interrupt you? Did
Yes,
they
sir.
ever refer to the oppression they had in Cuba?
My mother tried to paint a good life. My sister and I have pulled the pieces apart and realized that she had a very hard life. My grandfather, my mother's father, left home in search of a better life and abandoned the family. And so they had to struggle on their own. And so it was things like you couldn't paint your house because then the communist government would know that you had money, extra money. So it was things like that. She doesn't like to talk about it because she wants us to appreciate and not what she endured.
Okay. Mr. Cantor, when we met last week, I mentioned my concern about concentration and anti-competitive practices in farming, excessive corporate consolidation in the agriculture industry, harmful to the family farmers. Recently, I've been particularly concerned about competition problems and lack of transparency in the cattle pricing. Earlier this year, I wrote a letter urging the Justice Department to investigate the control that large meat packers have over the meat processing market and whether this control violates antitrust laws. So as head of the Justice Department's Antitrust Division, what action would you take to combat anti-competitive marketing behavior that hurts farmers and raises consumer prices at the grocery store?
Thank you, Senator, and thank you for raising awareness to this critically important issue. Our food supply, our agriculture, our farmers are critical to the health of our economy and to a healthy nation. And so this has to be a high priority when enforcing the antitrust laws. It's vigorous antitrust enforcement in the area of agriculture is absolutely essential, in my view, to any effective antitrust enforcement program.
I hope you'll work with this isn't a question, I hope you'll work with the Department of Agriculture to make sure that the Packers and Stockyards Act is fully used, and even encourage that using if you have to. I'm get on to the next question. The rising cost of prescription drugs. That concerns my Iowans all the time at my county meetings. The Justice Department plays a critical role in ensuring that drug companies don't engage in anti-competitive practices or monopolistic behavior. What steps would you take if you're confirmed to enforce the antitrust laws in this space and ensure that both brand name and generic drug companies play by the rules?
These are critical issues that affect Americans every day. Access to affordable medicine, healthcare, cannot be more important. And so the antitrust laws play an important role in keeping prices down, allowing for access to important care so that people can be healthy and live. And so antitrust enforcement here as well is absolutely critical. And if confirmed, I intend to work with the Department of Justice to ensure that we have vigorous and responsive antitrust reform in this area.
Congratulations to all of you.
Thank you.
Very good. Thank you so much, Senator Grassley. In fact, I'll focus a bit, I say to the other panelists. Antitrust is my subcommittee. A number of other senators here have been working on it as well. Senator Blumenthal, Senator Whitehouse, and we also have, of course, Ranking Member Grassley, who's been such a leader. Picking up where he left off, Mr. Cantor, Senator Grassley and I have a bipartisan bill, of course, the Merger Filing Fee Modernization Act, which would update the merger fees, raising $135 million in additional revenue. We've worked this out together so that the money would come off of the biggest mergers and not off of small companies. In fact, we've reduced those fees. Maybe some small companies in Iowa, for instance, that might want to merge. So we've worked that out. It's actually passed the Senate. It's passed the U.S. Senate. I think it would help both agencies given that they're a shadow of their former selves, even from during the Reagan administration, and yet they're being expected to take on the biggest companies the world has ever known. I know that you voiced support for the agency funding when you testified before the Antitrust Subcommittee when Senator Lee, who's just arrived, and I invited you to testify. As Assistant Attorney General, what would you do with the additional funding?
Thank you, Senator. Adequate funding is essential for effective antitrust enforcement. I know the Department of Justice has weighed in favorably in support of the legislation, and I certainly support any effort to provide the appropriate level of funding to the Department of Justice Antitrust Division. I think there's a great deal to do. We've heard about some of the issues today in agriculture and in healthcare, and there are a wide range of other areas where the Antitrust Division needs to be the cop on the beat in terms of ensuring that companies are complying with the antitrust laws. And so I think some of the things that I would recommend and that are important to me include more trial attorneys and more substantive expertise to complement the already tremendously talented people in the Antitrust Division.
Okay, very good. Yesterday we had incredible testimony, thanks to Senator Blumenthal, Senator Blackburn, and others on the committee from a whistleblower at Facebook. And as a former law enforcer, I know that effective enforcement often depends on the courage of ordinary people who provide relevant information to enable the government to build a case. This week, as I said, we can see what happens when we have someone coming forward. This is something Senator Grassley cares very much about. Given that whistleblowers who assist the government in civil antitrust cases may face threats of retaliation, could there be benefits to extending the protections offered to whistleblowers assisting in criminal cases to whistleblowers assisting in civil cases? Mr. Cantor.
It is extremely important that antitrust enforcement authorities have access to individuals with relevant information, and monopolies have the ability to intimidate even other big companies, let alone individuals. And so, as a general matter, I'm very supportive of any effort to ensure that the enforcement authorities have access to the relevant information and the relevant witnesses.
Very good. Some mergers are just too anti-competitive to fix. In my mind, that was the T-Mobile Sprint merger, which unfortunately got settled over significant objections. I'm not going to ask you to comment on individual mergers that may be coming before you, but could you describe the approach you plan to take in assessing whether the Antitrust Division should accept settlements in merger cases, and what will you do to ensure that the division does settle a merger case, the merged company actually complies with whatever consent decree that you reach?
I look forward to working with my colleagues, future, hopefully, colleagues at the Department of Justice to enforce the law vigorously. And that means adhering to the text of Section 7 of the Clayton Act regarding mergers. And, to the extent that remedies are on the table, the guiding principle is they have to work. If the remedies don't work, then you still have a violation of the law. And so, each case should be evaluated on a case-by-case basis. But it's important to make sure that we're addressing anti-competitive mergers.
Okay, very good. I may come back with some other questions of everyone, but certainly, if you don't mind, I'm going to go to Senator Whitehouse because I had allowed Senator Grassley to go first, and then you'll be next. Senator Whitehouse.
Thanks, Senator Klobuchar. Mr. Cantor, welcome back to the committee.
Thank you.
It is, as you know, we've been making inquiries from the committee on the conduct of your predecessor, Mr. Delrahim, regarding the investigative letter that was sent to the auto companies, which appears to have been undertaken without the proper procedural steps dictated by the Department of Justice internal guidelines and without proper substantive support in the law. I'm going to ask you to confirm that you will help support our inquiry, and specifically, if an antitrust investigation were announced without the proper procedural steps having been undertaken and without proper substantive legal support, and perhaps for the purpose of applying a political punishment, would that be a proper area for this committee to make inquiries?
First and foremost, Senator, I think there's, I have tremendous respect for the oversight function of this committee and Congress, and I look forward to, calling with my colleagues, working cooperatively.
That set of facts would be an appropriate justification or predicate for committee inquiry, would it not?
I think Congress has the right to ask questions, absolutely. And
if White House political pressure were the motive, would that also be an appropriate area for congressional inquiry?
Questions, enforcement decisions, and investigations should be based on the facts and the law, period, full stop.
So I'm taking I believe the Inspector General is investigating this matter. And I understand that we don't want to interfere with an Inspector General inquiry, whatever it is that is going on. But at the same time, the Inspector General's scope can be viewed as limited to what takes place in the department. And I offer for you the example that we all lived through of the investigation into the U.S. attorney firings, in which OPR and the Office of Inspector General joined together to try to get to the bottom of what took place there. And when their investigation led to the White House dropped the door, slammed it shut, and said, no info, no interviews, no nothing. Unfortunately, Attorney General Mukasey tolerated that, but that is the precedent, really, that the department has displayed when an internal investigation by the Inspector General leads to the White House, that it stops as soon as the White House says that it stops. So that means that, to me, that the Inspector General's investigation may be very complete within its bounds, but it does have bounds. And this committee can look beyond those bounds and can try to figure out what happened. And I want your commitment that you will support us in that effort and not just say, oh, well, the Inspector General is looking into that. That's all we need to do. The committee is not, I'm not going to support the committee's inquiries.
I am tremendous respect and deference to Congress's role in its oversight function, and if confirmed, I certainly commit to working alongside colleagues at the Department of Justice, including the Office of Legislative Affairs, to ensure that we are providing Congress with the information it needs as appropriate.
The last piece here is that there are rules that exist for contacts between the White House and the Department of Justice. Those rules have been the subject of committee inquiries before. I suspect they will probably be the subject of committee inquiries into the future as well. It's been a relatively long-standing policy with a few very embarrassing hiccups in it that have caused the Department of Justice to revert to the long-standing policy. But clearly, if there were violations of the Department of Justice and White House counsel policy regarding contacts between the White House and the Department of Justice, that would be a proper subject for this committee's oversight inquiries, correct?
Certainly, Senator. I think the operation of the Antitrust Division of the Department of Justice, I only can speak to antitrust, but certainly Congress has an important oversight function.
Great. Well, we look forward to getting to the bottom of what took place in this unfortunate episode at the department. Thank you, Chairman.
Very good. Thank you, Senator Whitehouse. We now turn to Senator Lee, who is going to ask the 4 judicial nominees a series of difficult antitrust questions. Is that correct?
Thank you, Madam Chair. Mr. Cantor, I'd like to start with you, if that's all right. In the first 9 months of this administration, we've seen some disturbing trends in antitrust law. And some of those trends are the focus of a letter that I sent recently, along with Senator Grassley and Representatives Jordan and Buck, to both the Antitrust Division at the Department of Justice and to the FTC, noting several recent developments that seem to reflect kind of a divergence between these two antitrust enforcement bodies. Divergences that I can't trace or justify based on any provision of sound public policy or statute. For example, we've seen the FTC withdraw its approval for the 2020 vertical merger guidelines, while the Department of Justice has retained that same scheme. We've also seen reports indicating that the FTC is asking merging parties about their environmental, social, and governance or ESG policies. Tell me, do you, if you're confirmed to this position, to run the Antitrust Division at the Department of Justice, do you intend to ask the subject of antitrust investigations about their ESG policies?
The purpose of antitrust law is to protect competition. And so my experience and in my view, questions that are relevant to protecting competition are the kinds of questions that antitrust enforcement authorities should ask.
And should they be asked where ESG policies pose no competition-related implications to the merger?
I don't see situations where ESG policies that are unrelated to competitive issues are relevant to antitrust enforcement.
As to the existence of these divergences, don't they just further underscore the problem that we've created with having two enforcement agencies charged with enforcing the same set of antitrust laws?
I defer to Congress with respect to creation of agencies. If confirmed, my focus will be to work with the Department of Justice to enforce the laws as Congress has written them and to make sure that we're protecting competition in the competitive process.
Okay, let's talk about the consumer welfare standard for a moment. You've criticized the standard in the past. There was a speech you gave, I believe in 2017 at a Federalist Society conference, in which you indicated that economists, quote, bring values and ideas that are often very subjective, and you compared employing the consumer welfare standard to judicial activism. Do you agree that the consumer welfare standard could encompass many factors beyond price, factors that we both agree are important, including things like quality and innovation and consumer choice?
Yes, I do.
So it sounds like the problem may not be with the consumer welfare standard itself, but rather with how it's used. And it sounds like your problem in particular that you were highlighting in your 27th speech might be in reference to the way judges might have used it in order to, in such a way that involves entertaining speculative economic analysis. Would you agree with that?
That's a fair characterization, yes.
Now, you've advocated for greater consideration of political values in the application of our antitrust laws. How would you define political values in that context, and how would you employ those here?
Let me start by saying political influence should not be a relevant factor in determining whether to initiate or bring antitrust enforcement actions. The kinds of values, are around protecting competition, and competition can yield a wide range of benefits, including protecting the free flow of information in a democratic society, which is critical to our political discourse.
Those value judgments, insofar as you're basically talking about policy choices, is it proper for individuals who aren't elected to be making those policy choices?
Yeah. So
either in the case of a regulator, an enforcer, or a judge.
Right. So I think when it comes to antitrust, which is the area I know and love, the focus is on preserving competition. And individual decisions regarding enforcement actions should be based on whether there are violations of the law as written by Congress and interpreted by courts. And individual enforcement actions are assessed on a case-by-case basis.
Madam Chair, I've got one other question. It's really tiny, I promise.
Okay.
On the consumer welfare standard, would you agree that once we separate out the concern that we discussed a minute ago, you can separate that out, the consumer welfare standard can be and often has been used in such a way as to focus the antitrust inquiry so as to keep it attentive to what matters, which is competition, protecting competition rather than competitors or some other social policy?
My view is that the antitrust laws exist to protect competition. I believe that's how Congress has written the law, and I think the mandate of antitrust enforcement authorities is to enforce the law and protect competition in the competitive process.
Okay. Thank you, Mr. Cantor. Thanks, Madam Chair.
Thank you very much, Senator Lee. And next up, Senator Blumenthal.
Thanks, Madam Chair, and thanks for your leadership of the Antitrust Committee, along with the ranking member, Senator Lee, which I know will be very active, and hope for your cooperation with us. Mr. Cantor, I'd like to congratulate and thank all of the nominees here today. Your personal stories are impressive and inspiring, and your commitment to the rule of law and justice is so important to our democracy, as you well know. And as a member of this committee, I've said countless times that our judiciary is often the face and voice of justice for many Americans. It's what they see and hear when they think of justice. So your position of trust is immensely important, not only to those of us who have spent a lot of time in the courts, but also to ordinary Americans. So thank you. Mr. Cantor, I want to talk a little bit about interoperability. As you well know, Google and Facebook have tremendous dominance, and they maintain it through moated castles, which in effect trap their users and reinforce their powerful network effects. They trap their users in effect on their platforms. And for startups, if you can't reach those users and their friends, you're doomed, no matter how much better your product is. So they are barriers to competition. Congress has used interoperability and non-discrimination as a tool to foster competition again and again and again for nearly a century. It's one of the most pro-consumer and pro-market steps that can be taken. It is now hard for us to imagine or to think back to the day when you were unable to port your telephone number to a competitive carrier. And I think there's a consensus that we need interoperability and portability requirements for the big tech platforms to break down these walls. There's a ton of conversation about breaking up these companies, which in some instances I do support, but a more modest and potentially hugely effective step would be to enforce interoperability and portability. Senator Warner and I introduced the Access Act, which would require companies like Facebook and Google to offer interoperable access for competition and consumers. This bill would empower companies that want to compete with big tech, for example, to offer better privacy, safer environments for children, and other pro-consumer benefits. There would actually be competition about who can better protect children, which is lacking now in part because of the lack of interoperability. So I would like your commitment that if confirmed, you will be working with my office to advance the Access Act.
It would be, I don't want to get out ahead of the Department of Justice by weighing in on specific legislation, but if confirmed, I look forward to working with you, your staff, and the committee as appropriate, along with others at the Department of Justice, to ensure that we have effective antitrust enforcement and providing the appropriate input with respect to sound competition policy.
Do you consider interoperability an important principle and potentially effective in protecting competition?
Yes, I do. I think the facts depend, or the remedy, as I was saying earlier, the first and foremost, remedies have to work. And so I think it should be assessed on a case-by-case basis, but interoperability is obviously a critical principle.
Are you familiar with the effects of lack of interoperability in big tech?
Without speaking regarding any specific company or case that might be pending, yes, I'm very familiar with the with interoperability issues, with interfaces, and the extent to which they can contribute to the kinds of competitive moats that you were referring to earlier.
Let me ask on a different topic, if you could give a brief answer, because I only have 30 seconds left. It's a big topic, and if you want to supplement your answer in writing, that's fine. Could you talk a little bit about the impact of protecting competition on communities of color, ensuring that communities of color are able to earn a fair wage and enter businesses?
Yeah, Senator. So antitrust is about promoting competition, which is essential to preserving a healthy economy that works for everybody. And dominant companies have the ability to exploit their monopoly power to the detriment of Americans in so many different ways, whether it's farmers, it's wage workers, or others. And I do think a critical mission of the antitrust law is to protect competition for people in the workplace, to ensure that thriving competitive markets leads to adequate compensation.
Thank you. Thank you all for your service. Thanks, Madam Chair.
Thank you very much, Senator Blumenthal. Next up, Senator Tillis.
Thank you, Madam Chair. Congratulations to all of you on your nominations. Thank you for being here. And you all should probably thank Mr. Cantor, because I understand he's getting the majority of the questions, and I'm going to keep the streak alive. Mr. Cantor, I want to thank you and my staff. We're very complimentary of the time that you spent with them on a variety of questions preceding the hearing. I want to get to a couple of things, and I'll submit the rest for the record if time does not allow. But the Antitrust Division under the previous administration really took a view that the policies of patent laws and antitrust laws were aligned with the mutual aim of fostering dynamic competition, keeping our leading innovation economy moving. But in June of this year, the acting Assistant Attorney General Richard Powell stated that the Antitrust Division is rethinking its approach to the intersection of antitrust and intellectual property. Do you agree that a reliable, predictable, quality patent rights promote vigorous, dynamic competition for the benefit of consumers, and that the Antitrust Division should continue to support patent rights as a key driver of innovation in a competitive American economy?
I was not at the Antitrust Division, still not. And so I can't weigh in on what decision was made and why. It's something I look forward to examining if I have the opportunity to work at the Antitrust Division and Department of Justice. I have tremendous respect for intellectual property rights and the important role it plays. My view is antitrust enforcement authorities should enforce the law and address conduct that has an anti-competitive effect.
I actually maybe drill down a little bit on a couple of questions for the record, but not too many. I intend to support your nomination. I should say that up front. I don't know if my staff know that, but you do. I do have a question about 2019 joint U.S. PTO, NIST, DOJ policy statement on remedies for standards essential patents subject to voluntary FRAND commitments. In particular, do you intend to withdraw or revise that 2019 joint policy statement? And do you intend to change the Antitrust Division's policy as reflected in that policy statement that antitrust law should not normally play a role in FRAND licensing disputes between SEP holders and potential licensees?
Senator, this is something I look forward to examining if I'm confirmed, and I wouldn't want to prejudge any outcome.
Last year, the Justice Department determined after its review that it would maintain consent decrees with ASCAP and BMI to remedy the competitive concerns that arise from the exclusive, collective, and blanket licensing of copyrights. What are your thoughts on whether and when it should be appropriate to lift the consent decrees?
I had the opportunity to work on behalf of some companies who are involved in that matter, and so I'll refrain from weighing in, given that I'm a pending nominee.
Okay, we'll do some follow-ups. I think finally, what's your opinion about whether certain large market players like Google and YouTube have an obligation under antitrust law to make tools like Content ID available on equal terms for all creators?
Without commenting on specific companies or issues that might be pending before the agencies or the courts, I've been a strong proponent of vigorous antitrust enforcement in the technology area, among others.
Thank you. Thank you, Madam Chair.
Thank you very much, Senator Tillis. Next up, Senator Padilla.
Thank you. I have a few questions for Mr. Cantor specifically. I appreciate the opportunity to have had a conversation yesterday, so I want to follow up on some of the items that we discussed then, particularly in regards to competition in our labor markets. Mr. Cantor, as the nominee to be the Assistant Attorney General of the Antitrust Division, you'll play a key role in enforcing antitrust laws and ensuring that the American people benefit from open and competitive marketplaces, not just as consumers, but also critically in the labor market. We need an economy that works for workers, full stop. And I hope that you will approach the antitrust responsibilities with a keen eye towards ensuring there is sufficient competition to prevent worker exploitation. For example, tens of millions of workers in America are required to sign overly broad non-compete agreements as a condition of getting a job, which by extension limits their ability to switch to better paying jobs if they come across that option or opportunity. These restrictions are found throughout our economy, ranging from the tech sector to quick-serve restaurants and a whole lot of industries in between. Even in California, where the state has banned the use of non-compete agreements, employers continue to try to use these restrictions to scare employees away from leaving for a better opportunity. Thankfully, labor exploitation has not escaped President Biden's attention, and I applaud him for his attention to this issue. He's encouraged the FTC and the Department of Justice to use their antitrust authorities to ensure workers have access to high-quality jobs with good pay, benefits, and terms of employment. So, Mr. Cantor, how will you address concerns about labor exploitation in your role as head of the Antitrust Division?
I wholeheartedly agree with the sentiments that you just expressed, Senator. If the antitrust laws are not working to protect competition to the benefit of workers, then the antitrust laws are not working. And it's, without a doubt, the antitrust laws apply to protecting competition to benefit workers. This is something the Supreme Court has recently reaffirmed in a decision involving the NCAA. So, if confirmed, I'm eager to work with hopefully my future colleagues at the Department of Justice to ensure we have a vigorous and comprehensive antitrust program that protects workers from anti-competitive abuses.
Well, thank you, and not just working with your future colleagues, if confirmed, but this very Congress, this very Senate, this very committee. And on that note, I want to raise a related but additional issue. Congress has exempted labor organizations from federal antitrust laws in order to ensure that workers could not be easily exploited by powerful employers. However, this protection does not explicitly extend to a major new sector of our labor force, gig economy workers, who are currently classified as independent contractors. More than 10% of workers rely on independent work for their primary source of income. And more than 25% of workers participate in the gig economy in some capacity. These gig economy workers who perform oftentimes critical services throughout the pandemic, food delivery, for example, are precluded from benefiting from the wide range of social benefits and legal protections afforded to employees, including their ability to collectively organize and bargain for better terms of employment without fear of persecution. This is an affront to fair employment, and it's also an issue of equity. Gig workers are more likely to be Black or Latino workers, more likely to be low income, certainly more low income than wage and salary workers. I'm currently exploring opportunities to ensure antitrust laws aren't a roadblock to gig workers who deserve to be able to advocate for their rights. Last week, the Federal Trade Commission Chair Lina Khan highlighted this very problem as one demanding the FTC's attention and action, the Department of Justice's attention and action, and she also highlighted it as a place where Congress could step in to provide workers with more protections under our antitrust laws. So, Mr. Cantor, do you commit to working with me to better protect our gig economy workers from labor exploitation? And if there's some thoughts in that regard you'd like to offer, I'd welcome them.
I look forward to working with all actors, including Congress, as appropriate, to make sure that the competitive process is working for everybody, including workers, and workers of all characterizations. And so I also look forward to examining the issue that you mentioned regarding the FTC and speaking with the Federal Trade Commission if I'm fortunate to be confirmed.
Thank you. Thank you, Madam Chair.
Okay, very good. Senator Blackburn.
Thank you, Madam Chair. Ms. Beckering, I'd like to come to you. 2006, there's an article where you were quoted as saying that the role of the courts is to remain nonpartisan, your term. However, you also went on to say that the courts also have a role in protecting the minority against the majority when they have overstepped their bounds on civil rights and on constitutional rights. So what did you mean by that, and how do you decide who the minority is in a situation? Isn't that really a stone's throw away from politicizing and putting partisanship on the bench?
Senator, the comments that I was directing at the time that I ran for the Michigan Supreme Court was a campaign of the requirement that the judiciary always remain fair and impartial. The comment that I made about protecting the minority from the majority was an effort to talk about the Constitution and that it is the job of judges to uphold the law. And the only time they overturn the law is when it conflicts, for example, with other precedent that is higher, and that includes the Constitution. That is the design of our Constitution, in America.
Okay, the same article, you said you wanted to apply a common sense interpretation of the language of the statute or law if you were elected to the Supreme Court. However, you criticized the then sitting Supreme Court in Michigan for taking a very liberal interpretation of the language. So how would you describe your judicial philosophy now? How has that evolved for you?
At the time I made those comments, I was speaking from my view as an advocate, and I was analyzing it from that perspective. The goal that I wanted is that...
Did you intend to take that advocacy to the bench?
No, I've been a sitting judge for the past 14 years, and so I
Okay,
applied
would
the
you
law.
describe yourself as an originalist or a textualist? What is your philosophy?
I would describe myself as someone who very seriously takes my oath to fairly and impartially apply the law, and as Chief Justice John Roberts has said, to have the same strike zone for every party that comes before me to make the court a level playing field.
Now, you have a history of donating to Democrat candidates exclusively. You were a max-out donor to President Biden's presidential campaign. You were also the Michigan Democratic Party's nominee for the Michigan Supreme Court. So as a judge, it is your responsibility to fairly administer the law regardless of your own political or social views. So how are the American people to be assured that you are going to separate your political and your judicial views?
Senator, I am bound by the Michigan Code of Judicial Conduct, and Canon 7 explicitly provides the ability for judges to make contributions to political campaigns. Advisory
So you see
opinion.
no conflict.
Advisory opinion 60 from the Judicial Tenure Commission has expressly stated that it is not an appearance of impropriety. And if I were nominated, I would follow
Let me move on to
the law.
Mr. Cantor. First of all, thank you for your time. Appreciate that. And we talked about where the DOJ starts, the FTC starts, the separation, the responsibilities that are there when it comes in the antitrust space. And but I've got a couple of questions for you on that. My time's going to run out. Talk to me. You have criticized the consumer welfare standard. And I want you to briefly walk through that, describe your thoughts on that standard and how it is applied to technology platforms. And as you know, the chairman and I each are working on issues of accountability in the tech space.
Yeah, thank you, Senator. So antitrust laws have to address market realities, and market realities have shifted in dramatic ways just over the last 20 or 30 years. And the kinds of harm that can be inflicted on society as a result of concentrations of power has also changed. And those harms can embody privacy, can involve the marketplace of ideas and the distribution of information, political discourse. And so to be effective, the antitrust laws, in my view, should be enforced in a manner that adapts to those market realities.
Okay. I've got a couple more questions. I will submit those to you for a written response. And thank you all for being here today. Thanks,
you.
Madam Chair.
Thank you very much, Senator Blackburn. And when you were gone, I mentioned your leadership with the hearing yesterday, in Commerce, which we really appreciated, your work on the App Store bill and other things. So thank you very much. I thought I would just ask a few of you who haven't been able to talk, one question each, talked very briefly. Judge Kumar, since 2015, you've served as the presiding judge, mostly for your family, right? We must ask one question. You served as the presiding judge of the Oakland County Circuit Court's Adult Treatment Center, is that right?
Adult Treatment Court, yes.
Adult Treatment Court. And I've long been an advocate of alternatives to incarceration. And I've been, when I was a prosecutor and then also here in this place, I pushed to increase funding for drug treatment courts. In Hennepin County, we actually had one of the first major drug treatment courts even before I got there. And can you talk a bit about the adult treatment court, why these kinds of programs are so important and why these alternatives. We now have some federal drug courts, as you know, but why don't you talk a little bit about this?
Thank you, Senator, for that question. That is a program that I am immensely proud of. I did serve as the presiding judge of our treatment court for over 5 years. It's amazing to see the transformation of these people who might have mental health issues. I actually handled both a mental health docket and a substance abuse docket, providing them treatment, helping them get employment, helping them get education. We actually had a graduation yesterday. I was unable to attend because I was here. I did send them a video, though, so I'm thinking of my participants today. The most amazing part is at graduation, the participants come up and their booking shots are shown, and then we see them stand before us, and that is amazing. It's amazing to see the transformation, and I know that they derive so much benefit from that program. It is so much more important than incarceration, particularly the treatment, and I know they are always grateful, and it's wonderful to watch their transformation and see them grow and be productive citizens.
Thank you. I, too, have gone to these graduations, and one of the most incredible things that I've seen in some of our more mid-sized communities, yours is a little bigger, but the people that graduate get to be friends through the program, and they stay friends, and even in some larger towns they do this, and really helps give them support when they get out. So
Yes.
Thank you for your work in that area.
Thank you, Senator.
Ms. Lerner, during your time heading the Office of Special Counsel, you received support from both Democrats and Republicans. As was noted, my colleague Senator Grassley sent a letter to the White House counsel in 2017 in support of your nomination to serve a second term, writing that you had built trust and confidence on both sides of the aisle in your ability to objectively and diligently pursue the office's mission. In your view, how has your approach to the law led you to have broad support from people across the political spectrum, and how will that experience leading the special counsel impact your approach to serving on the Court of Federal Claims?
Thank you for that question, Senator. I am really proud of my service, the Office of Special Counsel, and of the nonpartisan approach that I took to enforcing the law and making sure that government operated fairly and efficiently and effectively. And I had an even-handed, fair approach, I believe, that resulted in bipartisan support for my renomination. And, you know, as a mediator now with the court, I have taken some of those same skills, and I think it's really important to be neutral and give everyone who appears before you the feeling that they're going to be heard and that you don't have an agenda. And so that same approach that I took when I was special counsel, that I take now as a mediator, I would bring with me if I am confirmed to a seat on the Court of Federal Claims.
Excellent. Thank you. Ms. Beckering, I want to talk briefly about the importance of precedent, and U.S. District judges are bound to follow the precedent of their corresponding circuit court, Supreme Court. In your role as appellate judge on the Michigan Court of Appeals, your case record indicates you strongly adhere to relevant precedent when presiding over both civil and criminal cases. How do you view the role of precedent in our legal system, even binding precedent that you may think is wrongly decided?
I believe that binding or precedent is very important because it contributes to the even-handed, predictable stability of the law and the consistent development of legal principles. And therefore, I think that it contributes to the actual and appearance of the integrity of the court. It is not an inexorable command, but in my role, sitting as a Court of Appeals judge, it is what I do. I follow precedent. And if I were to become a federal district judge, I would follow precedent.
Not very good. And I noted that one of your quotes where you said, "My judicial philosophy is that judges should take off their partisan hats when they sit on the bench and treat all comers fairly and impartially. They should treat individuals and corporations alike, and they should make their rulings based on the rule of law, not on a political agenda." I assume you still hold that view. Do you want to add anything to that?
Thank you for that question. I ran for the Supreme Court because I felt very strongly that while I enjoyed being an advocate and representing my clients, and I felt the advocacy process is so valuable, I wanted to serve the state at a greater level. And so I took my philosophy with me to the bench, which is to be fair and impartial always, and I take that into account in every single case.
Okay, very good. Last but not least, Mr. Bonilla, on the side of the Court of Federal Courts Claim House is a quote from Lincoln that says, "It is much the duty of government to render prompt justice against itself in favor of citizens as it is to administer the same between private individuals." Can you discuss the importance of the role of the Court of Federal Claims, and if confirmed, how you intend to apply the sentiment expressed by Lincoln?
Yeah, thank you for that question, Senator. Having spent the better part of a decade practicing before that court, I understand the importance to the American citizens that the government hold itself accountable for its actions. As far as my handling of my docket, I will follow the guidance and example of the judge I had the privilege of clerking for, Judge Garrett Brown, the District of New Jersey, who was the most prepared in the courtroom of all the parties, knew the record better than any party, knew the law better than anyone else, and decided all cases promptly and made sure that everyone who walked out of his courtroom understood that the judge was well prepared and would rule based upon the facts and the law and nothing else.
Very, very good. And I do want the record to note here that if confirmed, you'll be the first Latino to serve as the judge on the Court of Federal Claims, which is a pretty cool thing.
Thank you, Senator.
Okay, very good. Well, this has been a really good hearing. We had good attendance despite the strange hour. I have a feeling all your families are really hungry and want to have lunch. Is that true of you, Cantor children? Okay, good. Well, good. I'm glad maybe you want more questions on antitrust we could ask you. That's all right. Okay, good. We're okay. Okay, you're good. All right. Very good. Well, thank you. And are we leaving the record open here, guys? Let's see. Okay. Questions for the record will be due by the nominees by 5 p.m. on Wednesday, October 13th. And the record will likewise remain open until that time to submit letters and similar materials. Have these letters also been included yet? They have, because I want to talk about, Arnold Schwarzenegger's letter, but I guess that's already gotten done. Okay. I send. It wasn't for you, Mr. Cantor. I'm sorry. It was for the previous nominee, Judge Koh. But in any case, I wish you good luck. I think you all did really well in the hearing, and the hearing is adjourned. Thank you.